Okay, that's why we'll let us see the file.
Party period, the court order dated 29.
Uh, Order dated 6/11/2023 reflects that hearing was concluded by a coordinate bench within bracket Soumitra Saikya J. Hearing of this case was concluded by a coordinate bench within brackets on 26/9/2023, and the judgment was reserved. It is further reflected that however, for non-availability of original records, the matter was listed on 6/11/2023, and a direction was issued to the learned DSGI the learned DSGI submitted original records of the departmental proceeding. Accordingly, a direction was issued to the registry to translate the record into English from Hindi. In the aforesaid backdrop, the learned counsel for the petitioner submits that the matter may be directed to be lifted before the said bench as the hearing was concluded. State bench within the bench. Such quiz for CGSE, Mr. S.S. Roy, learned counsel also. Anyway, learned S.S. Roy also submits in the similar line in view of this matter. In view of the process, registry to do the needful investigation. Please take. Yes.
Item number 7, man. Not accommodation. I am for IIT, man.
As agreed to by the learned counsel for the parties, please this matter.
Any date, the confidence.
After 2 weeks.
My lord, please.
It was called for by recording the statement of the method and as per earlier ordered statement. Recording.
No. So let us see. Yeah, on last occasion you made a certain submission that you returned the money and something like that. I forgot it. Logo said that will verify.
No, our pilot part is just stated para 6 and 7. These particular statements are not there in the case. So Lord Tarik that he will appear and he will make a statement. That's all. voice yet. Only after my lord leaving apart all this spectrum. My lord, this is the allegation which can do from the basis of the documents my lord that are there in the bank. He has appeared twice before the my lord. Whether my lord is my lord then the personal detention provided or not, that lord may consider otherwise. My lord. Yes. Twice he has appeared. Fact should be revealed by the my lord document that is seized or posted by the investigating authority from that bank. Documentary evidence. Don't consent or not consent. Who has given the consent. Yes. Just to prove
See,
by the
public trust, bank, this is the difficulty. We are not here to decide whether you.
so that's why my lord, leaving aside the merit.
No, we understand,
Details will be
understand, but
required.
only problem is that whether that agreement has been seized.
Yes.
That is a vital document. He will go scot free. He has a your 161 statement is nothing. Even updated is that instruct uh, uh, the learned additional public prosecutor because he specifically stated that he agreed to repay.
Yes.
There was a contract. It's easy. He admits that yes, I have done it.
Contracted on house.
Ah, so forget you may not require a custodial interrogation of team, but you need to properly investigate. After 3 years, the citizens will blame the court. Court accuse people. Isn't it?
Yes. Yes.
Instruct, I'm not recording anything.
Yes.
All Xerox copies. The learned additional public prosecutor submit that he may be granted some further time to get the case diary updated. Where it allowed list on after 2 weeks.
The intent
21st of February 2024.
for the connection first week of March.
First, give a first
First of
5th of March 2024. Interim order pass earlier shall continue. Is the next date. Will dictate. Hmm? Hmm? Just give me a minute. We'll dictate this order. Let him have some dictation is here. What is this IA by state?
I have for better practicing interim order that pass.
Have you relied on the decision of Ramlal?
No, madam.
2024 1 SCC 17. Twenty 1 SCC 175. Ramlal versus Seto. Now days are reversed. What lawyer used to do are now judges do.
But I relied on early.
No, no, your judgments are for your context, those are fine. But their judgments
Right.
subject to correction. Will give 2024 1 SCC 175. Ramlal versus State of Rajasthan and others. Heard Mr. D. Das, assisted by Art. For the petition. Also heard Mr. T. Majumdar, learned senior counsel, assisted by Mr. Learned additional advocate general, assisted by Mr. S. F. Roy for the state respondents and for uh, by way of filing the present writ petition, the petitioner has assailed petitioner has assailed an order dated 17/5/2018 issued by the Principal Secretary to the Government of Assam Social Welfare Department, page 59. Principal Secretary, in exercise of its power under Section 300, under Article 300, whereby the whereby petitioner was dismissed from service in exercise of power under Article 311 within bracket 2 of the Constitution of India, read with Rule 10 of Assam Services within bracket Discipline and Appeal Rule 1964. The litigational history can be summarized as follows. First, as follows. While the petitioner was serving as Deputy Director, Social Welfare Department, and was posted at North Kasar Hills District, or where? Not- at then North Kasar, now Dimasa.
Yes.
Then North Kasar District, Hills District. He was arrested in connection with Bokhista PS case number 170/09, registered under section 120 within bracket B /121/121 capital A IPC, read with section 25 within bracket 1-B within bracket capital A of the Arms Act. Full stop. The subsequently aforesaid investigation was subsequently the Union of India directed the National Investigating Authority to take up the investigation of the aforesaid Bokhista PS police station case by police station case. Accordingly, Bokhista police station case was renumbered as NIA case number 1 of 2009. Full stop. Next paragraph. In view of arrest of the petitioner, as discussed here in above, the petitioner was put under suspension on 6/6/2009. Full stop. Subsequently, on 13/8/2012, a show cause notice was issued by the respondent number 1. Respondent number 1, while the petitioner was in jail. Respondent number 2 was in jail. Full stop. Being aggrieved, the petitioner challenged the said show cause notice by filing a writ petition numbered registered as WPC number 1655/2014, primarily on the ground that he could not submit any reply to the show cause notice as he was in jail. Full stop. This court, by its judgment and order dated 2/6/2018, 2015, was pleased to keep the proposed departmental proceeding in abeyance till petitioner is released from jail or till conclusion of the criminal procedure. Full stop. So 1665 was disposed of. Okay. Thereafter, the petitioner faced the trial in connection with NIA case number 1 of 2009, and the learned trial court, by its judgment and order dated 23/5/2017, passed by the learned special judge 2013 learned trial court 23/5/2017, convicted the petitioner under section 17 of capital UA within bracket P Act 1967 and under section 12 within bracket B of IPC, and sentenced him to suffer rigorous imprisonment for 12 years with fine of rupees
120.
120B. 120B.
Typing error.
Okay, 120B. 120B and a regulation of 12 years with fine of rupees 25,000. Full stop. Being aggrieved, the petitioner preferred an appeal before this court, which was registered as Criminal Appeal number 233/2017. Full stop. The appellate court by its where is the date of judgment? No, no, acquittal. Forget about bail. Why we need that record bail?
11-8.
Mhm. Subsequently, the appellate court, by its judgment and order dated 11/8/2023, acquitted the petition. Prior to that, no, judgment to record. Thereafter, on being convicted on being convicted by the trial court, the impugned order dated 17/5/2018 was issued. It was passed as discussed herein above, and being agreed, the present writ petition is filed. During pendency of the writ petition, the criminal appeal preferred by the petitioner was allowed, and it is ended in acquittal of the petition. Full stop. In the aforesaid backdrop, the petitioner urges to interfere with the order of dismissal dated 17/5/2018. Mr. D. Das, learned senior counsel, argues the following. Argues the following. One, two, three, kodi, huh? One. Admittedly, Mr. D. Das, learned senior counsel, argues the following. 1, 2, 3, abar belegi khulga. Admittedly, there was no departmental proceeding against the writ petitioner prior to dismissal, prior to issuance of his dismissal order, inasmuch as such dismissal order was passed, the petitioner being convicted by the learned trial court, as the such conviction has been wiped out by an appellate authority, the the foundation for issuance of such order no more exists, and therefore the impugned order is liable to be set aside, and as a necessary corollary thereof, the petitioner should be directed to be reinstated. In support of such contention, Mr. Das, learned senior counsel, relies on the decision of the Honorable Apex Court, decision of this court in the case of Board of Secondary Education Assam versus Kushal Das, reported in 2021. Decided in writ appeal number 136 of 2021. Will not rely this citation. Full stop. Next. As the petitioner has ultimately been acquitted by an appellate court, the involvement of the appellant in the criminal case in question now cannot be made basis of terminating him from the service. And since the appellate was acquitted and it was a clean acquittal, the stigma attached to him of having been prosecuted in a criminal case should have been treated to have disappeared, and no argument can be allowed to be raised for justifying the order of dismissal on the ground of appellant's involvement in a criminal case. Full stop. Mr. Das relies on the decision of the Honorable Apex Court in the case of Narsingh Pal versus Union of India and others reported in 2003 SCC 588, in support of his contention. It is further contended that relies on the decision of Spencer and the decision of Honorable Apex Court in the case of S. Bhaskar Reddy and another versus Superintendent of Police and another reported in 2015 2 SCC 365. These are the three judgments you relied on. Per contra, Mr. D. Mojumdar, learned senior counsel representing the state respondent, argues the following. Full stop. The present petition is not maintainable in absence of paragraph. Mr. Mujumdar, your dictation has we have already been recorded, but we'll add these judgments now. Okay. Ikini thakibo tarpisot.
Few months after few weeks
That's why I keep these things. Mr. Mujumdar further contends that mere acquittal of government employee does not automatically entitle the government servant to reinstatement, inasmuch as it would be open to the appropriate competent authority / employer to take a decision whether the inquiry into the conduct is required to be done before directing, reinstating, or appropriate action should be taken as per law. That being the position, this court may not like to interfere with the order of dismissal only on the ground that the petitioner has been acquitted. An opportunity should be given to the employer to apply their own mind to the given facts of the present case, whether the case is of a clear acquittal or a benefit of doubt has been granted, and such exercise may not be carried out in exercise of power of judicial review by this court. In support of such contention, Mr. Mojumdar relies on the decision of this decision of the Honorable Apex Court in the case of rendered decision of the Honorable Apex Court rendered in Union of India and other versus Bihari Lal Singha reported in 1997 4 SCC 385. Next. Mr. Mojumdar further contends that the acquittal of the petitioner in a criminal court will not preclude the employer to initiate a departmental inquiry against the petitioner. It is further submitted that disciplinary authority is not bound by the judgment of the criminal court if the evidence that is produced in the different departmental inquiry is different from that produced during the criminal trial. That being the position, the employer is within its competence to initiate a departmental proceeding at this stage also. Submits Mr. Mojumdar. He relies on the decision of the Honorable Apex Court in support of Honorable Apex Court rendered in Karnataka Power Transmission Corporation Limited versus C. Nagaraju and another, reported in 2019 10 SCC 367. Next. প্ৰথমটো যে মেয়াৰ একুইটেল বুলি ক'লো, তাত লিখিব also relies on the decision of the Honorable Apex Court in 2013 1 SCC 598. Deputy Inspector General of Police versus SS Samuthiram, Samuthiram. And আগতে দিব তাতে দিব 2005 7 SCC 764. Ajit Kumar Nag versus General Manager Thailand. Mr. Mojumdar therefore concludes that the employer be given a chance to apply its own mind to the relevant factors of the case in hand and take a decision in this. Yes. Yes, yes. That's why I have dictated here.
I also argued that it is not a case of honorability.
Mm.
In
No,
the-
that we have said. That's it. Therefore, we have relied on these two judgments.
Yes.
Honorable acquittal. That
Right.
we have recorded. তাতে deposit honorable কথা হচ্ছে। Mojumdar referring to the certain paragraph of the appellate court submits that the acquittal of the petitioner cannot be treated to be an honorable acquittal, and therefore this court, that we have said in exercise of
Ma-
judicial review, should not enter in whether it is honorable or not. That it should be left to the wisdom of the employer.
I'm sorry, but I
Okay, this court has given anxious considerations to the arguments advanced by the learned counsel of the parties. It is undisputed that it is undisputed that no, the judgment relied on by the learned counsel for the parties from the decisions relied on by the learned counsel for the parties. The following propositions of law are discernible. A following provision of law can be carved out. Acquittal by a criminal court does not preclude a departmental authority against a delinquent officer to proceed department. Next, the disciplinary authority is not bound by the judgment of a criminal court if the evidence that is produced in departmental inquiry is different from that produced during the criminal trial. Inasmuch as the object of a departmental inquiry is to find out whether the delinquent is guilty of misconduct under the conduct rule for purpose of determining whether he should be continued in service. Next, the standard of proof in a departmental inquiry is not strictly based on rules of evidence. Okay. Next is a mere acquittal does not entitle an employee to reinstatement in service. However, full stop. Though honorable acquittal may connote different meaning in the context of a case in given facts of the said case, when the accused is acquitted after full consideration of prosecution evidence and it is concluded that prosecution has failed to probe the charges leveled against the accused, it can possibly be said that accused was honorably acquitted. Even if an employee is honorably acquitted by a criminal court, no right is conferred on the employee to claim any benefit, including reinstatement. for the reason that standard of proof required for holding a person guilty by a criminal court and inquiry conducted by a disciplinary proceeding is entirely different. Therefore, the issue whether an employee has to be reinstated in service or not depends upon the question whether the service rule contains any such provision for reinstatement and not as a matter of right. Full stop. Okay. When next. Now coming to the case in hand, two aspects of the matter are required to be recorded. Firstly, a show cause notice was issued. A show cause notice was issued on 13/8/2012. Where is that? Page 48. Hmm? Huh?
Page 40.
Page 48. Show cause notice was issued with the following charges. Roman 1, 2, 3 করে দিব। The petitioner involved in illegal activities and illegal and unlawful activities and corrupt practices. And the petitioner was also charged for corrupt practices and misappropriation of fund, resulting loss of government money meant for various schemes of the government. The statement of allegation amongst other alleges alleges withdrawal of money from government exchequer to the tune of 17.02 crore and shortage of government code, which includes 9.85 crores routed through cash book, etc. The list of witness discloses that all office staff of the Office of the Deputy Director, Social Welfare Department of Long, The statement of allegation relevant for determination of this case are quoted here in below. Page 50, pen mark. However, however, such, however, this court in its order dated 2/6/2015, is that it? 2/6/2015, passed in WPC 1655/2014, preferred by the petitioner. No, 2/6/2018, was pleased, directed to keep the departmental proceeding in abeyance till the petitioner is released from jail or till conclusion of the criminal procedure. Thus, it is seen that a departmental proceeding was initiated and the said proceeding was kept in abeyance by this court till the by this court till release of him from jail or till conclusion of the criminal procedure. However, the other aspect of the matter is that finally the petitioner was acquitted by the finally the petitioner was convicted by the learned trial court and the order of dismissal was passed in view of such conviction, inasmuch as Article 311 within bracket 2 permits such course of action. Not only that, Rule 10 of the Assam Services Discipline and Appeal Rule also permits the employer such course of action. Therefore, the impugned dismissal relates the foundation and basis of dismissal of the petitioner from service by the impugned order is his conviction by the trial court as discussed herein above. However, the petitioner was acquitted from the charges by the appellate court, and therefore the basis for his dismissal is wiped out. Rather, the foundation no more remains. That being the position, and as discussed herein above, termination remains. Termination remains. However, as discussed herein above, and the ratio laid down by the Honorable Apex Court, the acquittal of the petitioner shall not preclude the respondent's employer to continue with the departmental proceeding as initiated by issuing the so-cause notice dated 2/6/2000. So-cause notice dated 13/8/2012. Inasmuch as this court has clarified such position that the departmental proceeding is kept in abeyance only for the period of conclusion of the criminal procedure and criminal proceedings concluded by virtue of the acquittal of the petition. By virtue of the acquittal of the petition. The petitioner was also under suspension with effect from 6/6/2009 for the reason of his arrest in connection with the department. In the aforesaid backdrop and in the settled proposition of law, this court is of the view that the order of dismissal in exercise of power under Article 311 shall not be sustainable on this date in view of his acquittal from the criminal charges. However, criminal charges accordingly, the same is interfered with. However, the authority shall be at liberty to take a look into the matter afresh as regard the afresh. Or Mr. Majumdar, should we go whether it's an honorable acquittal or not?
Maybe required. It's not honorable acquittal.
I do not think it is an honorable acquittal.
There, some of the
Okay. It is an we'll dictate this order later. This court has also gone through the judgment of the appellate court and relevant portion so far relating to observations and determination made so far relating to the present petitioner as summarized below. The aforesaid conclusion in the considered opinion of this court has been arrived at after full consideration of the prosecution evidence, and an unhesitant conclusion was held by the appellate court that prosecution has failed to prove the charges leveled against the accused. That being the position, it cannot be said that acquittal of the petitioner is not an honorable acquittal. Accordingly, the order of dismissal passed in exercise of power under Article 311 within bracket 2, read with section 10 of the Assam Services Discipline and Appeal Rules is interfered with. However, this court is also unhesitant view that the department shall be at liberty to proceed with the departmental proceeding initiated by issuing a show cause notice dated 13/8/2012, 13/8/2012, 13/8/2012, inasmuch as this court kept the said departmental proceeding in abeyance till the petitioner is released from jail or till conclusion of the criminal procedure. And conclusion of criminal procedure will mean the conclusion of the appeal and not necessarily mean that criminal proceeding, not necessarily mean either conviction or acquittal. Conviction and acquittal, inasmuch as discussed therein above, even after acquittal of the petitioner, the department, the employer shall be within its liberty to proceed department. Accordingly, it is clear that the department shall be at liberty to ensure. As the petitioner was under suspension, the such suspension will continue for a period of next period of how much? 3 months. In the meantime, the employer shall be at liberty to proceed with the departmental proceeding, and in the event they proceed with the departmental proceeding, they will take a conscious decision on continuation of the suspension of the petitioner, and in the event they are desirous not to proceed with the departmental proceeding, a specific order be passed and petitioner be reinstated immediately thereafter. Such exercise will be carried out within a period of 3 months from. It's up to you. Suspension will continue. If you proceed, you proceed. If you
Last observation that is not with me, it better go ahead. But the proceeding has already been initiated.
you are at
Hence,
liberty.
not with-
that we have said. That will be some fine tuning.
My lord, yes, in the last paragraph.
No,
may
that
again
will be
see-
fine tuning. That will be
it will
fine tuning.
create some-
We are not saying anything. You have initiated started.
Ah.
The
They will take it.
judgment says that, so therefore you are at liberty.
Well.
Whether you take that liberty or
Well.
not, it's up to you.
Well.
But if you do not proceed, reinstate it.
Yeah.
And if you proceed, take a call
Well.
regarding suspension.
Well.
This will be the order.
It's been terms of the judgment for the court.
I think this can be the possible order.
And your lordship is held that it's not an order.
No, it will held that it's an honorable equity. But because evidences are there and your allegations are totally different. Except one charge that he was involved in criminal case. Your other charges are withdrawing money, taking this.
Why I argued that it's not a portable equity.
Mm.
One is some of the witnesses can't. Secondly, my lord,
Mm.
as far as the other, because there were two parts. One is misappropriation, and then
No, understand.
misappropriation part has
if-
remained. Till now, it has remained.
That's why.
Yeah.
That's why we have given you for misappropriation part.
Yeah.
That's why we are saying, even if it is honorable acquittal, but misappropriation part you can very well go. Therefore we have said it. That's why we say that there are two distinctions. One is only, one's part is only, and your witness is also different. That will not make the harder clarification. You are there to advise.
But
We'll have some fine tuning,
Madam,
but we'll not get this order.
Not-
This we cannot. We have to do something. Otherwise, it will take a month. If it goes to the, once it's CAV, it will minimum take a month.
how it's initiated, it will end.
And
Simply okay.
now we'll have a pressure, now we'll have to clear it. Yes, next case. Code, print out code. Print out code. Itu না থাকলে আমি করবো কাজ। একটু যে আমি ডিপোজি চলে গেলাম তারপিছত তোমার আরো কন্টিনিউ আছে জানে না যে আমার বলে কিনি প্রিন্ট হাতে ফেলে আর এটা তুমি Mr. Shetty, have you gone through Nayak? Anything to be added? Have you given it to them? What's your college? I'm going to
But let us complete the hearing, Lord.
Okay. Okay.
That will remain, Lord.
Okay.
I went through that order live streaming, but no, but.
Okay.
So let my friend complete that file.
Anything to be added?
Yes, sir.
Here, my lord, here, some of the private respondents were also here. As because, since,
Just how many petitioners?
here, my lord, really,
There are only one writ petition.
yes, not the one.
How many petitioners?
Here, my lord, if, totally 17 people. Now, some of the persons have been retired.
Just a minute, that part we want to record. Total 17.
Yes.
Who retired?
Retired, my lord,
Just let us have the preliminary things.
petitioner number 3 in
Total
December,
17 retired,
petitioner number 3,
3.
Siliconi Das. He
Then
has retired in December 2023. And
just a minute, I will mark it in the petitioner 3.
and
December
December 23.
23. Okay.
And petitioner number 7
Petitioner number 7,
is retired in 2020.
2022.
And petitioner number 11
Hmm.
is retired in
He will also be 2022.
22 months, my lord, I do not know.
Not 2022.
And petitioner number 11 in 2021.
Now,
Among others,
now,
petition number 10 he has been
promoted.
promoted. And
Petitioner number 5,
5.
promoted.
Yeah. Now out of 17,
Hmm.
3 retired and 2 promoted.
Hmm.
Now 12%.
Then if respondent number 3 retires, then 2 has also been, 2 is also retired
He is going to be retired in February.
February. Okay.
And others are also at the verge of retirement. But this one is going to be retired in October 20.
October 24.
Like this, my lord, others are 58. Like now, since it was filed on 22 or 21, now almost they are 57, 58.
Okay. Now, what about this
Now,
respondents?
this respondents, my lord,
Hmm.
they were added as respondents because
They were promoted
they were promoted.
in relaxation of the rule.
They were promoted even after operation of the amended. The amended rule was 13/6/2009,
Hmm.
and they were promoted
Hmm.
on 24/6/2019 by taking into consideration the old rule. Since operation part was there from 13/6,
Hmm.
rightly, wrongly, whatever the process is there.
But record says in their case relaxation was granted, and they said that each and every case is no relaxation.
Relaxation was not started, but there the process started prior to the date of coming into of the new amendment. So it is continuation of the, but people kindly see order
let
dated
me
14/12.
Okay.
One line on,
Okay.
one line of
Ah.
14/12/2023. Prayer other than ABC has been given up. So the other persons at no, paragraph that order.
No, that order is taken into consideration. That if otherwise I have to bring the.
No. Yes, that
Yes.
we have recorded. So you. So
No, I will not disturb, provided my case is considered by.
no, you cannot have both. Suppose we hold that your cases ought to have also be considered. They are senior. We cannot ask government to create posts.
Yeah.
More particularly, suppose there may be some notional promotion to the retired, but those existing who are for 51, 52, for them, the others will have to give way. Then whether
My simple submission, their promotion order is now not under challenge.
that is what it is.
That, my lord, this promotion order not under challenge, my lord,
Okay,
6
fine.
months.
You want to say that is still under
Yes.
challenge. Now,
Yes.
who represents them?
My lord,
A person was there, but after this prayer, Lord, they are not yet.
no, they did not file an affidavit, only they appeared, and probably they will be there. They will be there. Because they are
Where is
representing,
Jai Barbuya?
and only my prayer is that since the operation of new rules came into with effect from 13/6/2019.
19.
Then they have promoted the person.
Hmm.
Well,
On 24,
on 24/6/2019.
19. Okay.
That part I have understood. That process was continuous process.
Hmm.
I have understood. Now, they have also promoted the higher secondary pass candidate in on 31/12/2019 after about 6 months. And they were the continuation process cannot be because
No, no, say,
they-
suppose
they-
for a moment, let us presume, just let us clarify our preliminary position. We proceeded on a context that their appointments are not under challenge. Whether basically exercise of power of relaxation is properly done or not. This was fundamentally the issue on that day. Okay, this was not a conclusion, but if you still say that no, since hearing is taken place, all the prayers or things we will still continue. No problem on that. This was an interlocutory order. You made a submission on that given day. Okay, we'll accept it. Fine, we'll not throw you out. But in that event, we'll have to notify this Mr. J.Y. Borpia. He might have seen, okay, my order is not on the challenge. Why should I waste time? That may be a possibility. Where is J.I. Borpia? That will be a proposition.
so that part is a lot clear. My lord, only my parties since in 31st of December 2019 they have also promoted with the old rule 1963.
Mm.
And they say that it was a continuous process.
Mm.
Their submission.
Okay,
But
3112 others were
My
appointed.
my submission was
Who are appointed on 3112?
some of the persons I have.
Tell us who are respondents.
Yes, respondents here 11, 12, 13, 14, 15, 16.
11, 12, 13. That is J.I. Borpia represents 11.
Yes.
15. S. Parveen. Okay. Suppose we say no, you could not have done on 31/12 is 2019. Now what will happen?
Well, since they have done, they have been some of the persons have been dead.
Hmm.
Now my contention is this, and moreover, my lord, what they did, they to be a eligible candidate, he or she must have to pass the B group training.
Hmm.
And the rule came in 13 June 2019. They passed the B group training with me in July and November. B group training. Then only they will be eligible for promotion. Now they passed in later stage, but their cases have been promoted for superintendent.
Okay, sir.
Now my only grievance is, my lord, if that can be done, my lord, if with the old rules they have been considered in discriminatory way, when there is a provision in the new rules itself to relax the person, and my lord, I'm not saying that the newcomer, new appointment has to be relaxed. Since I have I'm working at the department having with the old rules for more than 30 years. Now these persons are going to be retired. Now at least it's the authority had to consider this promotion, my lord, at least under the since the relaxation provisions have been laid down, and if any hardship is caused, if any that in a whole sum, my lord, if not for an individual person, but as a whole for the class, if it is required, then it can be done under the rules, and that is why, my lord,
Accepted.
and that is why, my lord, in corollary, my lord, which is this whatever they have done,
Understood.
if that 1963 would not have been applied,
Hmm.
certainly this rule would have been applied 2009. And then this respondent number 13, 11, 16 would not have been promoted. That part.
So, sir,
Now-
listen to me. So you want to
The
say
discretionary part.
discretion.
Yeah.
So, according to you, if you have applied a parameter, apply to all of them.
Yes.
Or not.
Yes.
Okay, this is your case.
Yes.
Suppose we hold your arguments to be correct. There is a discrimination because these are one group of people. And there is a pick and choose policy. And therefore, this is, I think, your argument.
Yes.
So therefore, while applying the relaxation, you will have to use a standard. Isn't it? Suppose you will have to use a standard for promotion. Suppose we fail that convention.
And application of fine, whatever law has said that
Hmm.
the proper application of fine has not been.
Okay. Proper application of
And-
mind
and-
is not
and-
there. There is a
and
discrimination.
Discrimination.
Therefore, the course of action left for this court. What is the course?
Well, of course, if the court is followed to, but now mandamus cannot be issued. That promotion in the promotion matter, mandamus cannot be issued. That part is well known. But direction can be given to consider their cases, in view of the provisions of Rule 16, since rule has been taken into
No,
consideration.
there is a problem there
Sure.
also. Because suppose there is a group of people, 5 people, 10 people, or 15 people. They are equally situated in an equal position. The allegation is that these people are discriminated. Some persons equally situated are given an advantage, others are not given. This is your case. So therefore, the others should also be given. So these equal persons, there must be equality before them. Now, therefore, suppose there are there are 18 people. There are 5 vacancies. Out of 18 people, 5 juniors or similarly situated but juniors are given promotions.
That's what I-
Others, that is your case, that other 12 or 13 are not given. Those are before this court. So the moment we hold the decision discrimination, we'll have to interfere with the promotion given to those junior persons so that the next 5 vacancies available can be accommodated, or you can be accommodated in those 5 vacancies. Can we say, no, you have given to these 5, whether you have to post or not, you give other 17.
70, here, since there are only now.
No, only 17 is just used as a
Yeah.
word. There may be 10 vacancies, but there are 5 vacancies, just presuming there are 8 people. 3 are not given, 5 are given, 5 are junior. Now,
Now the problem is now this regarding seniority and seniority. Since 2020 itself, they are giving the promotion to the junior person, and it's continuous process. In a year, 2 or 3 times they have given the promotion. And now that part I
no,
have-
problem with this court is, we want to pass an order which can be complied with. Clear order. Not an order ifs and buts. So suppose we hold your argument that there is a discrimination. If discrimination, we'll set aside the promotion of others. And we'll say that use the same parameter among these equal, whoever gets. That can be a consideration. We will not decide who will get. But for that, we'll have to give them the field cleared. Isn't it? There are 5 houses already constructed. But they were not entitled for the house. You were entitled. Or may not be only the petitioners, there may be some other who has not come to the court. So you'll have to say clear this field and give this, consider all of the cases of their cases and do a fresh
that
exercise.
part, my lord, I have brought into my reply. That I
No,
have
what is your answer to that?
made the chart, my lord.
No, understand. So therefore, you not propose in view of the earlier order that we should once again notify that no, he has abandoned that submission. Is not it? That is what I want to. We cannot pass an
Yes.
order setting aside their appointment. On that date was a different. You said that I will not proceed. So we proceeded with the hearing.
No, that part only, my lord, since in earlier repetitions, though this is second round of it. In audit, there was no such, the private respondents were not added. as such. But subsequently, when one after another.
No, that we
persons
understand.
have been
Uh.
modified. Then after going through this circular, all these things, I have thought it proper to add them as party respondents. Get the,
At moment,
and lot is right.
if I am right, what is the proposition today?
But since then the here or any person who appeared, not only
Oh, some appears. But today we cannot say that they have now not appeared because now it is a virtual. You have made a submission that we are
Robert,
not
that-
challenging, that is recorded.
That,
That can be a ground of review. That
14
can be a ground of appeal.
you know,
that part only my submission. That part the lordship may look into that matter. In the event of consideration my case, my lord, I am not going to be disturbed for that.
No, that's why,
That
Mr.
is the-
Mr. Setri, our problem is, how can they consider your case without removing them if there is no vacancy? That will be a futile order. They will come, my lord, we cannot comply with this order. Do whatever you do. We cannot comply. You have not set aside their promotion.
That is why, my lord, only my the fair submission and my fair content. My lord, in the event of consideration, directing the authorities concerned to consider my case after the petition also.
They have
Then-
taken a
then-
specific stand. These are the reasons this is the reason. Is not it? It is
And
not
they
a case that they will say, there is no question of consideration. We have done whatever we have done.
Yes.
Now we'll have to determine whether their action is right or wrong.
Yes.
To do right or wrong. On the earlier occasion, he said that we are not going for that only. But if you insist on that, because there will be two things. If you say we are not challenging others' appointment, then there can be an order which at no cost can interfere with the promotion of the other. If we say that we are not assailing, that may lead to some order that may be adverse to you also. But if you say, no, I am sticking to all my prayer, including the challenge to their promotion, we'll have to hear him. Otherwise, we could have said none appears for the petitioner. Now we cannot say because there is a order which is not only recorded, but also live stream saying that you
Then
will
lot
not
to-
challenge this.
If so, my lord, I will call them on 8th lot will be. I will call.
14, 12, 2023 is the chief order. And this is not, it cannot be an interlocutory order. It's final order, so far as the rights of the private respondent. If any, it cannot be tinkered like.
Where
that.
is that order?
14, 12, 20,
Order dated?
14, 12, 2020.
Hmm.
Yes, given up.
On the day it was recorded saying so that in the event of that given the same consideration, my letter to the petitioner may not be their proposals may not be disturbed. But if not, letter somewhere, my letter, I have to raise the question because I have been impeached them as party respondent to get my petition in the proper adjudication. Otherwise, my lord, it was meaningless to carry them as party respondent. My very purpose would be
But you have made a submission.
that's true.
This is the difficulty. On the basis we have dictated almost 8 pages.
No, that part only I will bring to the honorable court the effect that if otherwise. That only the anomalies and this arbitrariness of the authority and the discriminatory. That part I'm bringing. If they have done that part, in my case, they are saying that this is the authority's discretion. And the Honorable Supreme Court has said in the similarly situated person, the parity in employment should be maintained.
No, parity is something different. And wrongdoing is something different. Your case is not a parity. Your case is of that they have discriminated you.
Yes.
So
that is-
moment discriminated means somebody is favored.
Yes.
They are favored. If we hold that yes, you have discriminated, your right under Article 14 and 16 is violated, then their appointment will go. Will not hesitate.
Yeah.
But to give up, to set aside their appointment, you said that we are not challenging their appointment. Only thing is that whether relaxation of
No,
rule
that-
in our case is considered.
No, that part is also my lord. The challenging is also, otherwise, my lord, I would not have been arrayed, my lord.
But you made a submission.
To set aside, my lord, the para set aside and pass the promotional order of the private respondent.
I don't understand, but on that day, you said that we are not proceeding with that. So first paragraph we have recorded is that
Which was issued under the old rules and in contrary to the new rules of 19. My lord, otherwise, my lord,
we have spent too much time. Now I'm reading my order. Everything is recorded.
the other part, my lord, we are not saying that, yes,
We have relied on judgments of Sandeep Kumar Sharma versus State of Punjab, 1997. Ashok Kumar and others versus 1998. So a non-application of mine. Mr. Nayak, you relied on State of UP and versus Vikas Singh. Is that it?
Thing one was there.
What was the citation?
Uh.
Just note it down. I could not write the citation.
Thought it is 2022 1 SCC 347. Here I am relying upon paragraph 4.1, 6, 7, 7.1, and 8. That is one thought.
that is the court cannot be matter. Only relaxation is a discretionary part of the authority. That is that matter of the third.
How much time we have spent in this case?
And I will rely some of the thought.
Yes. Proceed.
Let's say here,
This is Nayak, no? Okay.
lot of people will find The impugn letter at page 100, that has already a lot of has got to it. Page,
Which
page
has-
100, impugn order,
Yes,
page 100 of my report. The impugn order passed by the authority.
Hmm.
Thereafter, my lord, on that particular day, next page, my lord,
Hmm.
3.
Hmm.
Some of the persons again, they have been promoted in 2024, and 104. Again, I have submitted another application before coming to the High Court. 104. That's all. It has not been disposed of. It is pending as a
which one?
104.
You have filed another petition.
No, another representative. 30/10/2021. This is pending.
Want a shortcut for reconsideration of it.
That no, it's my duty, solemn duty, my lord, to advise your lord. Now, my lord, only
So you rely on a similar judgment. Why are you spending so much of time in this case?
here, my
Your
lord,
case is that you want a similar order for consideration of Asedur Rahman and 38.
that part, my lord, since in earlier cases that consideration, that part has been done. Now, only lot has been.
You want a shortcut, we'll do the shortcut.
Yes,
Yes, Nayak. Reject their case. Take the representation.
no, since lordship has heard the matter at length, only 2 or 3 things judgment I will rely on. Then lordship will hear according.
The problem is that Nayak's objection. So, even if we overrule Mr. Nayak,
This question will come forward.
that's why. If we say that, no, forget about this. This was in a
Not
course of hearing. That is not an application, okay, not by the petitioners on affidavit. It's a consent by lawyer. Okay, anyway. And we negate Nayak's argument for the time being. Then this matter will fall today. Because this was, nowadays you cannot say that decision only on, it's a recorded thing that you have withdrawn your 2-3 prayers. So they are happy. Why should we go there? Now they are not more necessary party. We could have deleted their name on that day itself. We have not done that. He's correct in that sense. Mr. Nayak is correct. Okay, suppose moment we overrule his objection, then we'll require to hear the other.
For proper adjudication of the case, it is up to your
If
court
you say that-
consideration,
Huh?
my lord, for proper adjudication of the case, my lord, suppose my lord, I have added them to
No, that you are adding, not adding is not a problem. You have added them rightly because you want to challenge their promotion. No quarrel on that. But on last occasion, you said that I have no grievance against this, only my cases is wrongly been not considered. So in that context, we have proceeded.
That is one aspect of
Ah.
it. And so far as discrimination part is
Ah.
concerned, I will show all the 54 persons were promoted not for tenure to him.
no.
Or tenure to him. His promotion.
So let
is
us proceed then.
in their case.
Let
not
us proceed.
yes.
Call Mr. G.I. Borbia. Call G.I. Borbia will proceed. If you can show us that they were senior and
subject to it is urgent because I'm not in hurry.
yes, he is having urgent.
because they are going to be retired unless that has been adjudicated, my lord.
No, we'll adjudicate. Today itself we'll decide, but Mr. J will come and say we cannot because this is all your creation. See, we have spent so much of time in this case.
No,
We will not hesitate to spend times in a given case. No problem on that. But this is the difficult position. You have a talk with Mr. G.I. Borbu and who are there and come back after some time.
at 2.
Question. Let us start with that. deducted by
What is this?
first the service provided the date of birth should be 1st of December 1984. Certificate
Just a minute, just a minute. Your date of birth is
1st of December 1987. As per the admit card submits that appointment. But in the certificate
what is the service
mark page number 26
page?
26.
When you entered into the service,
I got on 1st of October 1990.
first of
October.
1/10/1993. Join.
Yes, ma'am. As a lecturer of Murkong Select College.
Now, where is that document? Anything in the service book?
Service
Okay. Now, service book is signed by the principal on 27/11/1990. Who was principal at that point of time?
I thought that is the not the particular but
So, where is the original service book prior to you becoming principal?
but it's still responding to
Yes, where is your record? You are appearing for whom?
I'm appearing for accountant general.
No, account general not required. Where is the education department? Higher education. Name soon. Original records was.
Original record,
Are you interested to do this case sincerely?
original records are not there. If
On what basis you
papers not called for act- or my lord may give some time, I will place the record.
no question of giving time? Yes, accountant general, you have the record. Okay, then when have you become principal?
my lord, well, 2 years before retirement. That,
No,
that
tell us, not 2 years. When have you become?
well, that document is not that.
Mhm.
I was appointed as a that he served as a principal for 2 years.
What is the service book? That is what we are to do. Huh? But on 3/3/2020, Director of Higher Education Assam writes to you, Accountant General Assam, forwarding pension paper in respect of to ensure retired teacher pension along with service book. Along with a service book in original. Received from the President, governing body of Murkom Khaled College, we want this.
Right.
Where do you get that return back? You have received it.
Yes.
Where is the return back? Show us. You, Mr. Go to it. So you show us your return, that you have returned it. This is your receipt. Show us the return.
As per my instruction, my lord, June that has not been returned back by the APO.
You just go to it. Where is the returning of that? Where is your appointment order? Is it a vital document? On the basis of you say that my date of birth was registered on the basis of my admit card. Nothing is there. You file by an additional affidavit. Your petition is not complete.
At that point of time,
We'll not ask on piecemeal that you do this. What are you relevanting? See, I was appointed on such and such. Your whole case is that I did not have any control over my document. And this service record was created when I did not have any record. I do not have any control. How do you know that? Because your service record you have annexed where date of birth is marked is of 1999. You were principal at that point of time. Why will you not doubt you?
Sir, she was not the principal at that 1999, madam. She was the principal in year, madam, 2000, madam, 16, madam. End of
So
16,
what was the why?
she was a lecturer
What
at
was
that
the
point of time.
occasion? What was the occasion to have the only one signature in the service book in the year 1999?
Madam, madam, the respondents may produce their actual original records, madam. First,
Yes, what is your basis to recover? See, otherwise we would have taken 5 minutes to dispose of this matter. But we cannot be unmindful of the fact that you know your date of birth. You know your date of birth, correct date of birth. You were the principal.
madam, the principal at the existing,
I understand.
but not at the time.
No, listen to me. Listen to me. You are a principal when you retired from service. You know your date of birth. So you not know when you are supposed to retire?
But everybody knows that it's a good man. Madam, probably.
So are you not aware? How can you become a principal? You must have a minimum self-respect to notify that, see, I am the principal. I was supposed to retire, but there is a defect in my date of birth. How can you give you a scot-free?
Madam, they have rendered my service for a year.
Rendered your service for your fault. Why have you not intimated them?
And not intimation does not lead to fraud, madam.
No, may not be fraud,
Yes, madam.
but we may not give a recover, but we make a comment against you. It's not that you will get simply all the money. That's why you want to know whose fault is this. Where is that, Mr.?
Madam, respondent produce.
See, it is not a case of a grade 4 employee. It is a case of the head of the institution. You are a principal of a college. You were supposed to retire on this date. And your whole case is, yes, I was supposed to retire on this because I know my date of birth. But I am not aware that they have wrongly entered my date of birth to wrong date of birth. But you have taken advantage of this. How will you address this?
Rather,
How
I
will you
sub-
address this?
Well, I have submitted the correct department.
Hmm.
Well, it is
That
the-
ends the and this matters.
well, it is the
So I have
responsibility-
given
It's
correct,
recorded
I have
by the
given
report,
correct.
madam.
The later they are not issuing the notice. So let me enjoy for another 1 year.
But I had
You are
worked
a
for one-
principal. Mind, just remind yourself, you are a principal of a college.
I may be, a principal, but I worked at the of time. Madam. They rendered my service. They,
Rendered service for whose
And-
fault?
well, not for
You
me.
are the head of the institution at that point of time. Did
there
not,
is
did
no
anybody
manipulation, madam.
retire during that period? Or you are not even aware of anybody's,
Well, there's no manipulation in the service book, madam. If,
no.
but, madam, they
We
can
admit
produce the-
everything. There is no manipulation. But
Madam,
your
there-
silence, how will you answer your silence?
But the silence does not, madam, amount to fraud or misrepresentation.
No, we'll answer that. That's
No,
why
there is-
otherwise this matter would not have taken 2 minutes, 5 minutes to
So
decide.
there's a,
This
the
is
law-
not a
the
case.
law has been laid down to the Supreme Court, madam. Madam, in Pandey, state of Bihar versus.
Ah,
Pandey
Pandey Jagadis, sir.
Well, in paragraph 23, they have rendered my service, madam, without any objection. And there is no fraud or misrepresentation on my part.
Pandey Jagadis, there is every case is decided on his own fact. Pandey Jagadis, sir, was not head of the institution.
May not be head of the.
Ah.
But they have rendered my service, madam, without any objection. And madam, I'm not the one who has manipulated the service book, because at the time of
We'll see,
joining
we'll
my
see.
law,
Yes, yes,
So-
where is the return? Yes, education department. If you are not interested, then we are allowing this repeat.
No, madam.
What is this?
As my
Close it, close.
Frustrating.
if they have, as per my last instruction, that was not returned by the AG mallet. If that has been returned, let me give some time, I will produce the records, because at that time, at the time of retirement, the petitioner was serving as a principal. And
That we know.
yes, madam.
You need not tell us. We know that.
Some
That
time
is what we are saying for last 10 minutes.
some
You
time
need
may
not
be-
repeat that.
some time may be
Come to
given,
the
madam.
substance and contents.
I'll produce the records. Some time may be given.
Don't come to show your faces to this. Mr. Nath, what to do? Tell us. So casual, everybody. Uh, we fix things on this miscellaneous just so that we can decide only. Yes. June 2018. This is a dated. When have you retired?
Well, 31st of December 2008.
You ought to have retired.
Well, it's the 31st of December 2017.
31st 12 2017. Ought to have.
Yes.
You have retired on
31/12/2008.
your date of birth.
For 01/12/1957.
Why it is written 22nd of June 1958?
Well, I do not give service. Specific response for the admin of the service group and the governing body.
Robert Wood.
Who is representing governing body?
Notification served matter in the court. Name of capital.
There is no date when this was noted, when this was signed. Hmm. Hmm. Governing body, na? President.
Well, in 2019, minor the petitioner was not the president. It was not the president.
Second. You got areas also.
My lord, was deductible from that area, my lord. My lord, out of
7 pay area.
out of 21 lakhs, my lord, 15 lakhs was deducted from the RT and remaining tax was deducted from the first area. My service to render
What to do? Government is not sincere.
But page 40, if I go by the statement record in the service list also, the date of part of the so would be 22nd June 1958, and below my lord, so her retirement would be 31st of June 2018. But the petitioner has been working up to my lord, December. Even if we go by the service record. The petitioner was principal, my lord. He was also the member of the governing body.
What the governing body was doing?
The custodian of the service during her tenure.
was the only not
Yes, when will you produce the record?
2 weeks, I think. 2 weeks.
Your director will be present day after tomorrow. You need to produce 2 weeks time to
Madam,
produce a
one-
record.
One
We need not require your assistance.
one
This is a
Or-
part
or-
hard matter.
or my lord, ninth.
Friday.
Yes, ninth.
the petition was appointed as a lecturer uh, on being appointed as lecturer at Murkong Select College, Junai. The petitioner joined her service on 1/10/1993. According to the petition, as per her matriculation certificate and admit card, in terms of matriculation admit card, her date of comma, her age is reflected in the admit card as 16 years, 3 months on 2nd of April 1974. Isn't it? Accordingly, her date of birth shall be when?
1st of December 19.
1st of December 19, 1st of December 1957. It is the further case of the petitioner that her employer has wrongly mentioned her date of birth in the service book as 31/12, sorry,
1st of December 19.
1st of December 1958 instead of 1st of December 1957. The petitioner continued to serve in the college and was appointed as the principal of the same college on
The date you have
college in the year
Madam, 2 years before retirement, that would be Madam, year 2016, Madam, but the date
in the year 2016. Full stop. Though in terms of the age entered in the admit card, which the petitioner was aware, the petitioner was supposed to superannuate from her service on attaining the age of superannuation on 31/12/2017. However, as the date of birth was wrongly recorded, the petitioner continued to serve the college. However, such defect was detected by the governing body, which is reflected in the governing body, not like which is reflected. Governing body subsequently and accordingly when you were asked to go on superannuation,
Madam, be superannuated a 30% December 2008.
And in the meantime, the petitioner superannuated from her service on 30/12/2018 in terms of the wrong date of birth recorded in her service. Subsequently, such defect was detected by the governing body, and while calculating and determining the pension of the petitioner for containing amount of rupees. What was the amount?
21,27,840.
Was recovered from the pensionary dues of the petitioner for against the salary paid to the petitioner during her overstay, which includes arrears of pay in terms of the enhanced salary granted under revision of pay scale under 7th Pay Commission. Being aggrieved by the aforesaid recovery, the petitioner has approached this court. The respondent state, where is your affidavit?
Pilot 26/4. 26/4.
The respondent state has filed an affidavit and has taken a specific stand that the petitioner, being the principal in charge of the college, she was custodian of all the official record and responsible for all official dealings, process and verification of all records, including the service book of herself and the employees of the college. And therefore, when she is well aware of her date of birth as a principal, she ought not to have overstayed in her service. Rather, as a secretary of the college, it was her responsibility to intimate the governing body regarding her actual date of birth and wrong entry of her date of birth, being the secretary of the college. And therefore, it is contended by the respondent state that in the aforesaid factual background, it cannot be said that petitioner has not taken advantage of the wrong committed at the time of entry into her service, and therefore the respondent state has rightly recovered the amount. Full stop. The service book annexed with the record bears at the first page bears a signature of the principal and secretary of the college, which is dated 27/11/1999, and the date of birth entered into the aforesaid service book also is clearly written. Therefore, in the factual backdrop of this case, this court directed the Accountant General A&E to produce the original service book of the petitioner by its order dated by its order dated 15/6/2023. Full stop. Mr. Medhi, learned counsel representing the Accountant General, while producing the record, brought to the notice of this court that original service book has already been returned by the senior accounts officer to the Director of Higher Education, Assam, by its communication dated 18/11/2020. In that view of the matter, the Learned Standing Council for the department submits that he may be granted 2 days time to produce the records pertaining to the service of the petitioner, including the original service book on Friday next. That is on so and so and so. Prayer is allowed to list this matter on the aforesaid date accordingly. List and list this matter as part heard on the aforesaid. Mr. Mehdi to retain the records produced, and the petitioner is to ready with the record, ready with her original agreement, on the basis of which, comma, according to her date of birth was entered. We request Mr. K. Gogoi, Learned Standing Council for the Higher Education Department, to assist this court. Registry to list this registry to list registry to list this case by showing name of Mr. K. Gogoi, Learned Standing Council for Higher Education. Nayok, you are the amicus here. You are party, but you assist us. You assist us. Forget about finance department for that day. Many finances cases are. Tell us what to do within a legal framework. No, not that, this case. Present case.
Or
Are you having the brief? That writer, extra writer.
Excellent.
Have you gone through his fact? They have raised a dispute, but apparently that's why you said you be an amicus informally. Apparently he was sent to training, he was continuing, everything is there. We cannot issue a direction as such for regulation, might be difficult. But how can we can mold relief and give some benefits to this?
it
What is your step? You say how Vidya is not working, that please be honest.
Honestly, with the submitted.
Be honest. It's not that it's an adversary litigation because
Yes,
somebody has filed, you will file an affidavit. You will send him to training, you will do everything. And when the writ petition is filed, you take a stand that disputed
Disputed.
question of it.
Classification, your classification.
You bring on record.
Your Lordship,
Don't say that dispose of today.
Lordship, I request you, I request your honorable court. He is still working. Still working.
We do not want to pass an order for consideration, this, that. You file an affidavit and give a copy to Mr. Nayak.
The last thing, today he is still for.
You want relief or you want a disposal? Tell us. You want a relief or you want a disposal?
I want to.
You want relief, so take your seat. Your job is being done by the court. Okay?
But-
Hard.
Lordship, I want to submit some letters some petition.
All latest judgments are inside out, inside my,
Lordship,
all these are there. My bundle in much more than you. Heard Mr. M. Kalka, learned counsel for the petitioner. Also heard Mr. S. Datta, learned standing counsel for the
Revenue.
revenue department. Mr. Nayak is here. Also heard Mr. Nayak, learned standing counsel for the finance. Stop. Seeking seeking regularization against a permanent existing vacancy as extra writer. It is the case of the petition that he was engaged on daily wage basis an extra writer temporarily for 3 months with a daily wage of rupees 25 per working day. And later on, such engagement was extended by an order of the Inspector General of Registration and was allowed to work in the sub-registry Jonai in the district of Dhemaji. And the petitioner is continuing to perform his duties till date. It is the case of the petitioner that subsequently his wages also been increased from time to time, and now he is getting a daily wage of
25 daily.
till now.
Till now. I like to say one thing, all officers managing by the employees of the shortage of staff, he managed. In addition to extra duty,
As per the instruction document. However, it is to be mentioned that I was attached to this office on 8/9/2023 and has been observed that he is engaged in this establishment prior to my introduction, and since then he is engaged till date without wage.
The petitioner still continues. However, the aforesaid wages paid to him, Mr. Nayak, here you will have to do something. You see the record, I am just that's why recording. Come on, with the event without any wage. The Mr. Talukdar, referring to certain annexers, submits that referring to annexer F, submits that by a communication dated 24th of May 2010, the Sub-Registrar Jonai has requested the Inspector General of Assam to appoint extra writer in the office of the Sub-Registrar Jonai, inasmuch as said communication clearly reveals that the Sub-Registry of Jonai is suffering due to non-availability of a regular extra writer and the documents have been pending since 2003, and the petitioner has been engaged on daily basis since 2009. However, no payment has also been made as against daily wages to the petitioner. It was further requested that the appointment of the petitioner may also be regularized for that purpose. But here was you have been saying for training. Where is that? Huh?
This paper.
Mr. Talukdar further contends that in the meantime, the petitioner has also been trained by the respondent authorities. And in support of such contention, he makes a reference to the Annexure M, a communication issued by the Inspector General of Registration Assam to the District Sub-Registrar Dhemaji, was requested to send the petitioner to was sent to undergo training in the year 2013, and as the petitioner has as the petitioner has already gone into completed his training, full stop, the comma, he was also engaged as a resource person technical. See, his expertise is required. Resource person technical to look after the works and to perform the job of technical support person in addition to these are normal duties. Full stop. Full stop. Being situated, though according to Mr. Talukdar, though he was trained as well as in the meantime acquired all the qualification to be appointed an extra writer, however, his grievances not being redressed, he approached this court by filing a writ petition being WPC 7552 of 2015. This court, under its order dated 23/7/2018, a direction was issued by this court to verify the case of the petitioner, and if it was found that if the petitioner is still working, he need to be paid his salary, which is due to him as soon as possible and within an outer limit of 3 months from the date of receipt of the order of the certified copy.
Earlier, yeah.
Huh?
Earlier also.
Okay,
In the
that's what we have recorded. Just we'll record the facts only.
My thought one thing.
It was also provided that in case of any filling up of vacancy, the petitioner be given a chance to participate. While situated thus as nothing was done, once again the petitioner has filed the present petition with the prayer of regulation of his services. Full stop. Mr. Dr. Learned Standing Counsel for the Revenue Department on instruction has submitted that the Sub-Registrar Junai by its communication dated 2nd of January 2024 addressed to the Inspector General of Registration requested the letter that petitioner is still engaged as extra writer and he continues to serve the institution without any wage. A reference was made that a prayer for regularization of his services was also made way back on 7th of February 2014. Full stop. It was also ascertained that the petitioner has been working in the office since 15/9/2009. Full stop. Mr. Dotto has also produced such communication dated 2nd of January 2024. Full stop. In that view of the matter, let Mr. Dotto file an affidavit, additional affidavit in opposition to bring on record those two documents. Full stop. In the meantime, Mr. Dotto shall obtain instruction as regards the proposal for regularization of the petitioner. Just we'll stop here only. We'll not go further. Okay.
Proposal of rejected earlier in the
Now, Nayok, whether that Upendas or something like at least. Then if not Upendas, then that judgment, Supreme Court judgment, that no, that equal, what is the equal scale, that judgment. That is there always, even if Upendas is there. Jagjit Singh. Jagjit Singh is there. Huh?
Lordship, I like to submit it.
Mm.
The extradition post is already sanctioned. Govind Peku has been kept against them.
It is also contended by Mr. Mr. Talukdar that the petitioner is still serving against a vacant sanctioned post of extra writer
Right.
in as much as the said vacant post is earmarked for scheduled tribe,
Right.
tribe community, and the petitioner also belongs to the said scheduled tribe community. Therefore, in terms of paragraph, in terms of the paragraph dash of what is that judgment you relied on last time? In terms of Secretary Karnataka, Karnataka and other Uma Devi 2006 4 STC voluntary, the petitioner is entitled for a regulation. This court will consider the aforesaid aspect of the matter. Is further submitted by Mr. Talukdar that even for a moment it is assumed that principle of Uma Devi is not applicable. The petitioner is entitled for equal scale of pay till his regularization in terms of the decision rendered by the Honorable Apex Court in Jagjit Singh and others, the state of Punjab and others versus Jagjit Singh and others, reported in 2017 1 SCC 148. This court will give this arguments and considerations advanced by Mr. Talukdar after hearing the learned counsel for the respondents. In the meantime, during the course of beneficial technical and submitted that proposal was given to Thailand. Okay. Please this matter on. Before a month, give it. 27th of February, February 2024 as a part heard, as part heard.
Because, when it when it different people for the regular different.
These are differently able person.
The last page it's particularly but it are get
Yes, not.
So they have given me the info. In fact, the person to a query made long back,
Mhm.
but it was provided. They have given me the same copy. But this is the same. According to the total capital strength of the post of supervisor is 2280. The regular is 1294 and contractual is 986.
Mm.
And total physically handicapped supervisor appointed till the date of advertisement is supervisor is regular post is 6 and supervisor in contractual is 60. That is the info. This information in fact was given 27 April 2023.
Same, this is the instruction
This is-
on the date of advertisement.
That is it.
Now, what is the matter about?
Here.
Are you going for final disclosure?
better criteria of that.
Look,
The product kindly come to the page.
What is the challenge here?
not considered of my
What about the appointments?
supervisor expert of state.
Appointments made already.
Appointments already made in 2006.
Hmm.
But we said that in this particular advertisement, there was no post earmarked for the physically challenged person. And the petitioner, although in the requisition he claims that he is a physically challenged person, but the annexure 1, the certificate which he has annexed in the requisition, this itself is not really at that point of time when it was annexed, because it was not a valid document at that point of time. And we said that since the advertisement was for 20 posts, no post was here for physically challenged person. After filing of the application, the petitioner has filed an application at annexure 5 page 30. This is a representation. By this representation, requested the Director of Social Welfare that our application to be considered as physically challenged. In fact, the annexure 1 is not a valid document.
Okay, we'll come back and here. We're going for final disclosure. Okay. That is a fair submission. In terms of this court's order dated 1/2/2024, Mr. D. Nath, learned senior government advocate, on instruction, has submitted that on the date of advertisement, from the date of issuance of advertisement dated 24/2/2014, 2014, altogether, 6 numbers of person under PWD category were appointed against regular cadre of supervisor and 19 persons were appointed against contractual post of supervisor. Full stop. Such instruction is is provided on the basis of a communication issued by the district soil protection officer, Directorate of Social Welfare Assam, Ujan Bazar,
Branch officer,
officer and branch officer establishment. উপরে দিব district soil protection officer and sort and branch officer, establishment within bracket attached, Directorate of Social Welfare Assam, Ujan Bazar. The petition for communication dated 27th of April 2020. Address to the Director Social Welfare Assam. Full stop. The learned counsel for the petitioner submits that a copy of the aforesaid communication may be given to him so that he can advance his argument on the next day. Prayer is allowed. Mr. Nath, will hand over.
I have,
Mr. Nath has handed over a copy of this, a copy of the aforesaid order dated 27th of April 2020 to the learned counsel. Please dismiss, as agreed to by the learned counsel for the parties, please dismiss that. On 22nd of February 2020 for hearing. It is hearing better admission. In the admission column. First, a copy of the aforesaid order is kept on record and marked as document X.
all right.
Okay, okay. Okay.
Just one short fact I want to bring it on record. That file one that it may that's not. On 22nd, it can be taken up for disposal.
No, then we'll not say it to be disposal. We'll say list this matter.
Matter on 22nd,
22nd.
subject to what he said.
Okay. Mr. Senapati, learned counsel representing
Respondent number 2.
respondent number 229. Respondent number 229 submits that he has received a record in terms of this court's order dated
7/11/2020.
7/11/2023. Full stop. The learned counsel for the petitioner submits that he wants to file a short affidavit to bring on a record certain facts. Full stop. Accordingly, 6 for an adjournment. Prayer is allowed. Please this matter on
22nd Feb.
22nd of February 2024. Full stop. In the meantime, the petitioner may file the additional affidavit if so advised. Full stop. Mr. Sena's petition shall retain the record. Full stop. List accordingly. Anybody wants to go home? Anybody will sit for some time? Okay, nobody wants to go.
I should be stick to earlier whatever they quoted. 14th page.
Just recorded.
That has recorded the.
Ah.
I should not go back, my lord. Only that part. Lot people will take into consideration that there had that part.
Okay,
Otherwise,
where is Nayak? Where is Nayak?
Otherwise, my lord, again, matter will go on. My lord.
Okay. Just wait for some time. Let the other matters be called. I do not think
I
anybody.
got it, my lord. Everything will be in process otherwise.
Okay.
So I thought.
Okay, we'll decide this method.
For that context.
What is this, Mr.?
If the petitioner was a lab technician in the hospital, then only he was dismissed for dismissed from service. I did inquiry. That was challenged for that lower court. That was upheld. Against that, they have come. To see whether the procedure adopted by the proceeding as well as
None appears for the petitioner on call. Though Mr. S.C. Kyle, learned counsel for the respondent number 2 and 5 is present and is ready to advance his argument. The matter is pending since the year 2016 and pertains to an order of dismissal from service. However, in the interest of justice, matters that's adjourned today and be listed on possible 27th of February 20. Yes. None appears for the petitioner on call. None appears for the parties on call. Including Mr. K. Gaur, learned additional advocate general, who represented the respondents on 19/12/2023 and was supposed to and it's supposed to apprise this court as to the status of cabinet decision. Yes, what is the status of cabinet?
No decision has been taken yet.
Let us proceed.
Dispose it of.
Huh?
Lord had said he'll dispose it of on the last date.
None appears for the petitioner are not. This method. It's a part two. Yes, Mr. Pathak.
But relating to my lord, to the next qualification. Uh, but for a both marketing and today that the one of the document was not quite with the they have the super method. So the method to declare the setup.
If we are going for final disposal, then we'll give first preference to Mr. Tetris matter is ongoing matter. Hearing is going. So we first complete that.
Okay, right. Okay.
Okay.
I
Okay.
have some instructions.
Okay.
We given a copy.
What is a part of our
Yes,
affidavit?
It was part of the meeting.
He had made a statement in a pleading, but it's not meant that that letter not shortcut keeps it within the report.
But this is not the way. We have to
Absolutely.
you file a short affidavit.
Yes.
Then you can misplace it.
Yes.
Mr. M. Sharma, learned counsel for the petitioner, has submitted that in the affidavit in opposition filed by the respondent corporation,
Yes.
corporation, at paragraph,
Paragraph N.
page
Page 5, your lordship.
is 5
Yes.
of the affidavit.
Yes. Page 5, your lordship, paragraph 4N.
At page 5.
Yes.
Paragraph
4N.
N.
The lowest most. Your
at
lordship.
page 5 at paragraph 4 N.
Yes.
Copy of letter dated 10/1/19.
It is not that.
Uh,
Your lordship,
Where is that 10N?
yes. That
The reply of the aforesaid letters, Professor Srimurthy or Principal
Yes.
Akram College, Commerce replied as follows.
I had
Comma, in paragraph. No, not copy of the comma. Mr. M. Sharma, learned counsel representing the corporation, has submits that the corporation in its affidavit at paragraph 4N has taken a statement that the principal of Sriram College of Commerce has answered a query to the effect that postgraduate diploma in global business operations within bracket GPO program is not equivalent to MBA/marketing, but its course curriculum has specialized subject in marketing. However, such communication issued by the principal of Sriram College was not annexed with the writ petition. However, he is having a copy of such communication and same has been also furnished to Mr. P. Pathak, learned counsel for the petition. Full stop. As the issue involved in the writ petition is regarding the equivalency of qualification, the aforesaid document shall have a bearing on the issues to be determined by this court. Accordingly, Mr. Sharma submits that he may be granted 10 days time,
I'll lift your lordship.
2 weeks time to bring that document on record by way of Mr. Pathak also submits that he may be also granted some time to go through the aforesaid communication and complete its instruction of the plan. In view of the aforesaid, matters stands adjourned and be listed after a week. After 2 weeks, in the meantime, the corporation may bring on record the aforesaid communication by way of
There was an interim order.
interim order passed earlier shall continue till the next date of listing given it. Mr. Tiwari. That's it, okay. No, don't grasp. Now, Mr. No, what happened is we are in the midst of a hearing.
Oh.
So we thought it, we'll continue with that hearing.
Very well. But actually, I was taken by surprise because the board was showing 5. There was a jump to 12. Then I came running.
Okay.
Since I
So-
don't use the lift.
If
Very-
time permits, we'll pick up if you want, or we can accommodate.
Lord, if this matter takes a long time,
It will
That-
take some time. Mr. Nayak is also
Oh.
to address.
so that's it.
Huh? No, he said he's go by that order. So we'll finish it up today. Huh? If possible, we'll dictate, or if not, then we'll make it skip. So that's why you are senior counsel.
Lord, put it be on 15 of
Fif-
this month.
15?
15th of February.
15th of February.
I for my.
Yes.
Some of the 15th, the
That-
calendar.
Okay, you have a
22nd, your lord.
22nd.
22nd? Hmm. 22nd? Okay. As agreed to by the learned council for the party, this matter on 22nd of February. What is the issue here?
Issue will not, it's a denoted dispute between direct dispute is the promotion.
Okay.
So
It will
that's
take some time.
very, it should. It should
And
take some-
when you and Mr. Chaudhary is that will take some time. Possible, it will take some time, but what are the other method? Fix. Any other date, free date? That will go, huh? 5th of March? Okay, 22nd will give
Yeah,
it back. We'll
22nd,
we'll give it. Okay. Yes, Goswami, what is your status?
Ready with it.
Huh?
Ready with it, meeting, sir.
You are ready. Okay, wait for some time. Will take some time, longish or shortish? 15. 8, already 8 meter. Yes, are you ready?
Better to have.
Lord, I am appearing on behalf of Mr. D.P. Bharat. Someday.
Is appearing for the hearing.
What is issue? What is the issue here?
Well, it is a terminated government service matter.
Departmental proceeding.
Given proceedings are there. Also, my lord.
Be ready with the record. Be record radio. Are you having the record?
He is coming.
Well, records are there, basically.
Yes, Mr. Bora.
Survey and so on.
Ready? How much time will you take? You are in the midst of a hearing. That's why we want to finish off that. Finish off the anxiety of Mr. Setri.
My lord, in our record, my lord, we have a record pertaining to the disciplinary proceeding that was conducted in a fair manner, my lord, by following the procedure. So on last occasion, my lord, your lordship wanted to know whether the petitioner joined there or worked in his transferred place of posting or not. So that will be revealed from the record of the Karbi Anglong Autonomous Council, my lord. Because as per our record, my lord,
Okay. Where is that order? Last order. Item number. This is the file. Which order?
last occasion one order was there to produce the record by the council.
They have the record.
You have to record. Okay, give a date. File also give a date.
Anything.
Yes. Goswami.
My lord, they prefer 15, but your lordship, that is of full. Then,
20.
for 28th, my lord, it was
20. I agree.
20 or 21st.
21st.
in that case, my lord, it will go to 22nd.
22nd is
21st.
Wednesday. Okay, we'll give it back.
Then let it be there, my lord. We'll
28.
My lord.
Okay.
20th.
Let him start 28. We'll spill over to
Yes, yes.
26.
I will not be there, my lord.
Let him. I will say put some.
They have got a very
But my
limited role, my lord. It is basically Karbi
Karbi Anglong.
Because my lord, the main question is whether he joined and worked there or
So,
not.
Karbi Angla,
Yes, my lord, and from the disciplinary proceeding records also, my lord. So if it is not.
we'll start on 28, we'll spill over to 20.
Yes.
Okay.
Obvious.
28. Be with the record, or if you have problem, put somebody with the record.
Yes. Obvious.
Matok. Who?
You can,
No, he cannot appear. We know that.
he has been elevated and I have
Is it?
sought for his. Sought for his.
Don't take his name. He's how many months is passed? How many months?
From November.
Then now those days are gone. 15 days there is a contestant.
I know that
Maximum per month.
also I have communicated, but they say that the management needs to take a call, take some accommodation.
Okay. When? You're not fixing a date, make a mention. Any urgency?
Out of that, there was, it was made of, but the date, take out that
Okay. Mr.
MMP.
MP Sharma, Guarded Counsel for the petitioner. Seeks an adjournment. Full stop. You are Mr. Kolita. A. Chakravati, Learned Counsel for the petitioner, has expressed urgency in the matter. Has urgency in the considering the tribal but you do it.
Sure.
And after a month you cannot take a ground that somebody.
But actually the worker is there.
Why wakalatnama is required for senior? Huh? Which department? You are for a private school. What is?
PNPL from the target,
Oh, PNPL Limited.
PNPL.
Least before any other method. Make a mention. That gas company.
Nice.
Yes, what you want to add, Mr. Chetri?
It's let's I must say that
What
point,
happened?
that point was it about the now I'm picking you up. Here, my lord, they have also filed where they have connected in the case of some other person that said para for of their activity. That would that would regard to statement made in paragraph 22 of the
Which paragraph?
para 4.
Paragraph.
The second part, my lord, second paragraph. Now, it is a fact. It is a fact that the department had issued an order in respect of district court of consisting of candidates holding graduate with some non-graduate candidates. The DPC meeting was held on 4/6/9, that is prior to the with effect and selected 40 numbers of candidates for the but due to non-availability of qualified candidates for the cadre of deputy secretary. Now I'm for the superintendent for deputy secretary. Now, Lord, we find. The selection committee suggested the department to move.
Where? 13 where is the meeting of the selection committee under chairmanship of Chief Secretary Chuancho for
Yes.
promotion to the cadre of additional secretary, joint secretary, deputy secretary, and secretary was held on 4th of June 2019. The selection committee recommended various candidates promotion to the cadre of additional secretary, joint secretary, under secretary, superintendent as per existing rules, and notification for promotion is the 24th of June 2019. Isn't it? Okay.
DPC meeting was held on 26th prior to the enactment of new rules effect from 1319 and selected 40 numbers of candidates for the post of superintendent.
Where are we?
No,
Uh-huh.
it is
Page 3, paragraph 4.
paragraph 4 of second paragraph. It is
It
a
is
fact.
fact.
It is a
Okay.
fact. Yes. It is a fact that the department had issued promotion order in respect of 53 numbers of superintendent in 2009, consisting of candidates holding graduate degree along with some non-graduate candidates. The DPC meeting was held on 4/6/19, that is prior to the enactment of the new rules 2009, with effect from 13/6/19, and selected 40 numbers of candidates for the post of superintendent. Now,
No,
But-
no. Initially, recommendation was made for the promotion to the cadre of additional secretary, joint secretary, under secretary, superintendent. Okay. As per rule, and according to them, its selection was completed prior to enactment of the rule, isn't it?
enactment of
Or on 4th of June 2019.
that enactment was made
On 13th of June 2019.
13.
So they say that on the date of recommendation of the selection committee, rule was not holding the field. This is their stand. Now, what are you saying?
But- Now,
Hmm.
it was subsequent matter. But due to non-availability of qualified candidates for the cadre deputy secretary,
Just a minute. DPC meeting was 90 prior to and selected 40 numbers of candidates for post of superintendent.
like
Hmm.
that is superintendent.
Hmm.
Now, but due to non-availability, there was allegation. That is why they are
So amongst these 40 persons, qualified candidates were not available. Or what?
that is qualified, not qualified, the higher secondary and graduate degree candidates were considered by virtue of this 4/6/19 DPC. I'm not on now second pair. But due to non-availability of qualified candidates for the cadre deputy secretary, the selection committee suggested the department to move to percentage B department with a proposal for relaxation of relevant provision, and after obtaining the approval, another DPC meeting was held, which was specifically declared as an extended session of the earlier DPC, and again some candidates were selected for the post of superintendent from seniority of both graduate and non-graduate. Now they have also made the relaxation for both candidates. Must have the
So
within
on 4/6/2019, you were not within the zone of consideration. You admit
Yes.
it. On 4/6/2019, you were not part of the DPC because you were not within the zone of consideration. When have you become eligible in terms of the earlier rule?
that is
That is very vital. Date.
not even some other persons also.
No,
That
not only you, all the parties.
Is the month of July, the
So on 4th June, there could not have been any consideration of your candidature, even if the rule was existed on that.
date. Okay, pertinent. He has to complete minimum 5 years of
Hmm.
as a senior. That eligible have I completed.
No, you have completed, but that
But-
is not the only criteria. Suppose
Criteria.
there must be some
B group rate.
B group training in
Is
respect of earlier rule.
Yes. Earlier rule, this rule also approved. So B group training is also essential.
So you have
Right.
not acquired the qualification on the date of recommendation in terms of the old rule. So therefore, your case otherwise could not have been considered on 4/6/2019. Do you admit this position?
4/6/2019. Yes, I admit, but thing is this.
No, no. We'll go
Yes,
to the
yes,
but
yeah,
we'll go.
and-
On 4/6/2019, even otherwise, if new rule would not have come or whatsoever, in terms of the old rule also, you were not qualified to
That
hold
is-
the bill in terms of you have, because though you are having the required length of service, but you did not acquire the
B group thing.
B group training. Am I clear?
Yes.
Yes.
And on that aspect,
Hmm.
I must also apply to
Hmm.
that those persons who did not have the B group training
Hmm.
and who subsequently passed B group training in July and November,
Hmm.
they have been promoted in December of the
In which DPC their cases were considered? On 4/6.
that 4/6 matter if that has been done, then
No,
you
no.
must have to be eligible like me.
Hmm.
I was not eligible. That is why my case was not considered. But their
No,
cases,
their cases were considered in which DPC?
that DPC was it was already in 31st of December 2019. They have been considered, but they,
No, no, date of DPC.
that of DPC I do not know. That part I do not have.
But that DPC must be under challenge.
But that DPC, my lord, I am not would not have the book rate. Similarly, they are also in the same category. They only
Who are those who are those persons?
this respondent number is 13, 14, 15.
So
They did not have. My lord, to that extent, without having this eligibility criteria, how on 4/6/2019 the DPC can select it.
no, 4/6/19.
That on
4/6/19 is a date when you did not have the qualification.
myself and even this private sector.
So do you say that if this respondent number 12 to 15 cases were considered on that date? 4/6.
I do not know, but
No, but you are saying that they were considered 4/6.
they are saying that this is the continuation process. They saying, but they have not produced that particular record whether that has been done. And if 4/6 was there, then certainly he has it or he or she has completed the people rating. That was not done. And now a lot of people will find my reply. I given the record, the document. Lot of people will find my reply, my lord. Kindly have a look, my lord, that notification. The minute is there. Oh, that's my lord, TPC was held on 24/12. I'm sorry.
Where is that?
Lot of people will find in
We
my
are not ready with the facts, Mr. Shetty.
lot of people will find in my reply.
Let us understand the facts.
Lot of people will find my reply. Just I don't know. Page 13. At minutes of the meeting of the selection committee held on 24/12/19 at 4
Where?
page 13,
Yes,
page 1.
of your affidavit.
The minutes of the meeting of the selection committee held on 24/12/19 at 4 p.m. in the office chamber of the secretary to the cadre of the secretary and superintendent of the secretary. Members present. The meeting of the selection committee held on 24/12/19 at 4 p.m. under the chairmanship of Sri Alok Kumar IAS, with the objective of recommendation of candidate for promotion to the cadres of deputy secretary, under secretary, and superintendent under secretariat service as an extended access to the meeting of the selection committee held on. The meeting has been held to consider increase in vacancy following relaxation of required qualification in respect of under secretary for promotion to post of deputy secretary and subsequent vacancy thereof. Now, Lordship will find the member secretary apprised the selection committee about the number of vacancies together with the results of each cadre, and also place the SCR statement.
Now come to page 100. For you are the your post are meant for superintendent.
Superintendent and under secretary. I for the superintendent.
You are for a superintendent. So let us come to the stated superintendent. How tell us Jogeshwar Raskwa, junior PU, any of these respondents. Page 1, for page 14. Tell us who are senior PU and you have been deprived.
Here, my lord, this persons have been
They have been
promoted.
Huh?
They have been promoted, my lord.
Promoted.
Yes. Promoted on the basis of
By relaxing the rule. By
by
relaxing the rule, they have been promoted.
Yes.
Now,
Only-
who among them who are senior to you?
No, my lord, here relax the rules. That part, my lord, already I have stated in the reply.
No, tell us.
Yes.
What- Out of
That-
these 14 persons, there is two persons. One is STP, SC, STP. These cases are even if they are junior, they are under reserve category. Amongst other, who are your seniors, the juniors that has been considered, your case is not perfect.
Now, my lord, here, my lord, some of the persons here in 2019 who were appointed, who were promoted, of course, they are senior to me.
So you
They admit-
admit that these are senior to you.
These-
Mr. Ansel,
These are the those are the senior, those are the persons who are senior to me. But only I want to say that I'm not on that.
now your case is that is
Yeah.
sum and substance.
Yes.
Here cases are
Relax.
considered
Consider.
by relaxing rule. My cases are
That,
not
that point I
not
want to make.
exercised by relaxing
Yes.
the rule. Therefore, there is a discrimination.
Discrimination.
That's all.
That point I would like to raise before.
Yes.
That's all. Because now, my lord, 19, now we are in 2024, my lord. So naturally, my lord, only other than showing some discrimination or some arbitrariness, my lord, now
No,
probably
there is no there is no arbitrariness so far relating to the promotion. Even if
senior.
we can enter into that merit and reject your case because none of the person is senior to you.
Yes. Now,
One of the criteria is seniority. Only acquisition of qualification is so there are 9 unreserved posts. 9 senior persons are considered. 2 STP candidates. That is no STP is there in this repetition. No STH, no SC. So forget about this post. So far relating to the 9 general, admittedly all are senior to you. So even if you are not equally situated, they are senior. So their appointment at any rate
No.
cannot be interfered.
I'm on
So therefore is your
No,
silence. No, you have silenced it.
Yes.
That's why. So that part is gone. Now the question remains is whether relaxing a rule in a given position for a class of candidates at one point of time shall give a right in all future point of time, those employees who are still situated at all that of 9 persons to get relaxation automatic. That is the issue.
My lord, only on this.
And if we
Discrimination.
hold that, yes, if they are also entitled for relaxation, then the question of discrimination will come so far relating to. So you will have to address on that point. That relaxation once made should be applied in all future cases.
In-
They have said, okay, we cannot do in all the cases. We have done in a given case.
In page 16, Lordship, I have one, this statement has been fixed and accordingly closed as annexed. My lord, this, here the petitioner, my lord, their serial number has been, as per the gradation list.
Mm.
That has been inserted here. Serial number, seniority, my lord, Dilip Chandra Das,
No,
77.
yes, I've seen that.
Now,
Who were appointed?
now this, the junior person
Mm.
who are junior to me,
Mm.
the serial number from, start from 81,
Mm.
82, 83, 87, 88, 90.
So these people are not before us.
So those people are not before us, but only some of the persons have been added as respondent. My lord.
But
Everything,
those
my lord,
added as respondents are senior to you.
my lord, everything is not possible to add.
If not possible, how can you help me?
Now only question is this, my lord. I'm not against them, my lord. Now without adding them as a party respondent, probably for setting aside their promotion, all this, I'm not on them. I'm not on them. Only on my very,
So therefore, this document is having no relevance.
no, my only grievance is
Your only grievance is that
to consider my, to reconsider
They have-
my case
they have
on the basis
considered
of,
and rejected. So we'll have to determine whether that rejection is arbitrary
Yes.
or violative of Article 14. That's all. Otherwise, if they have taken a policy that this will be in one time for DCR only.
no, that policy, that has not raised, my lord. So that point, my lord, only regarding the relaxation. Whether now on that particular point, Lordship has said the regarding power of the court, whether it is a discretion or whatever the power has been empowered. That part, Lordship, I would like to say something.
Yes,
Both
say
my relax-
something on that only. These
Yes.
are irrelevant.
And in other cases also, they have considered that
No, that we have seen.
I have other documents, my lord, to rely on for. My lord, now I would like to rely that Lordship is aware about the
Which has no?
probably that document is available before Lordship is single bench.
Which judgment?
Susmita Sutradhar.
With the
Sutradhar. My lord, may I place it?
yes.
Let me check. And some of the judgments, my lord, I have noted here. It will be easier for
Smita Sutra. For which paragraph?
Lordship to find.
13.
13 to 2021 real.
Very good. The same one, my lord. As far as the issue of relaxation of essential
the case of the petitioner was indeed considered earlier by the state authorities for relaxation, but the same was not acceded to. However, when queried by this court, it was informed that the state decision was taken on 29/8/2018 and not at the instance of the court. While this court is not making any observation about the state rejection by the authorities, this court would assume that whereas the authorities were more concerned of the problems it may create in future by relaxing the state qualifications for the petitioner. However, in the present case, as mentioned above, as the petitioner has only a few days left for retirement from service, and since it is a one-time measure, as also explicitly mentioned in Order 28 of the Orders of 2017, this court is of the view that it would be a fair and proper decision if relaxation is granted to the petitioner as regards non-possession of BEd degree by the petitioner for promotion to the post of additional director. If the government has already relaxed the service rule for giving double benefit in the interest of the administration, this court would hold that further relaxation by exempting the requirement of possession of BEd by the petitioner in view of her long service and experience in the department cannot be said to be an unreasonable one. 14. On the other hand, because of mere possession of BEd, many of those who were junior to the petitioner will overnight become senior to her, even without discharging the duties and holding the post of deputy director. Thus, this one-time exercise will have the effect of adversely affecting the interests of the petitioner and can be said to be arbitrary and discriminatory as far as the petitioner is concerned. In the light of the above observation, this court expects that the state authority would take necessary steps for relaxing the aforesaid requirement of possession of BEd degree by the petitioner and also in respect of other two employees mentioned above, so that this one-time relaxation measures undertaken by the authorities come to a closure without any disillusionment on the part of any of the remaining existing incumbents. Though the aforesaid two persons, namely Srimati Meena Kumari Bora and Dr. Utipul Borua, are not before this court, considering the nature of their case and similarity of the situation in which they are placed with the present petitioner, this court, without their appearance before this court, has made observation that the authority will also relax the qualification in respect of the case, these two employees also for grant of double promotion. Accordingly, under the facts and circumstances as discussed above, even though the state authority had rejected the case for relaxation of the requirement of possession of BEd degree by the petitioner, the state authority will reconsider the matter and take a fresh decision for rejecting the requirement of BEd degree, so that the petitioner and aforesaid two persons, namely Srimati Meena Kumari Bora and Srimati Utipul Borua, can also be given double promotion as given the other. The state government will thereafter issue necessary consequential orders for double promotion of the petitioner to the post of additional director and other two persons named above to the higher post by giving similar benefits as given to the other private opponents. The petition is then disposed of according to earlier interim orders. The recommendation made by the Departmental Selection Committee held on 10/2. As regards the private opinion and the consequent promotion order of the private opinion shall be given effect to. In terms of expenses, is also disposed of the order of parliament. Now, the next one. The division bench of this High Court, my lord.
Manishutri.
Yes, Manishutri has. Okay, my lord, para 10, 12, and 14. My lord, initially, my lord, I will read over the para first 3 and 4 mile. This will understand more.
Yes.
When the petitioner was expecting consideration of his case for promotion to the post of Deputy Director, Science Promotion Wing, the state government, in exercise of power conferred by the provision to Article 309 of the Constitution of India, has framed another set of rules. Vice Mizoram School Education Department Group A Post Recruitment Rules 2013. 13 rules in short, to regulate the method of appointment to the post of Deputy Director, Science Promotion Wing, SCRT, under the School Education Department, Mizoram,
It is a part of the 2013 rules regulating the method of appointment to the post of Deputy Director Science Promotion, which has been put to challenge in this restriction by the petitioner. The petitioner is aggrieved by the repeal of the 1987 rules and its replacement by the 2013 rules. As per the 2013 rules, the post of Deputy Director Science Promotion Wing, SCRT, is to be filled up 100% by way of promotion. Insofar as impugned part of the 2013 rules is concerned, it is prescribed that the post of Deputy Director Science Promotion Wing, SCRT, is to be filled up from the grade of science consultant who possesses the minimum requisite qualification for direct recruitment for science consultant, with not less than 5 years of regular service in the said grade. Accordingly, according to the petitioner, the educational and other qualifications required for direct recruitment in the post of science consultant is at least second-class master's degree in any science subject, including mathematics, with not less than 5 years experience of teaching science in a recognized institution, not below secondary school level, or BSc with physics, chemistry, mathematics, botany, or zoology, and a postgraduate degree, public teachers training with experience of teaching science for not less than 5 years in a recognized secondary school. Working knowledge of Mizo language has been prescribed as a teacher qualification. 5. It is a case of the petitioner that when he was appointed as a laboratory bearer in the year 1982, he possessed the requisite qualification prescribed for the said post. During the subsequent period, also, when he was promoted to the post of library assistant, science supervisor, and science consultant, he fulfilled the necessary criteria to be promoted. It is when he has been serving in the post of science consultant, the recruitment rules have been changed to his detriment and prejudice. It is his further case that, though he does not have the prescribed qualification for direct recruitment laid down for the post of science consultant for being promoted to the post of Deputy Director, Science Promotion Wing, SCRT, as per the 2013 rules, he, by dint of his long years of experience in the post of science consultant, has acquired the eligibility to discharge of the duties and responsibility of the post. It is the submission of the Learned Council for the petitioner that the petitioner has expertise to man the post of Deputy Director, Science Promotion Wing, SCRT, since it is an administrative post. For an incumbent to hold the state post, it is not that essential for the incumbent of the state post to have qualification in science department. Though the repetition, this is somewhat, though the repetition, the petitioner has challenged the virus of the part of the rules in so far the qualification prescribed for promotion to the post of Deputy Director. Since science wing principle is concerned, indicated above, the Learned Council for the petitioner has, during the course of hearing, submitted that he is not urging the same. Instead, he has referred to Rule 8 of the 2013 rules in support of its contention in respect of the petitioner alternative care. That for consideration that the relaxation of. And accordingly, my lord, now lot will come to the rule 10, para 10, my lord. Para 9 is the opinion, my lord, this rule, what the Rule 8 says. Para 9. From the submission of the Learned Council for the party, it has been found that the issue has become confined to Rule 8 of the Rules 2013 rules, which has provided that the power of relaxation to the governor for ready reference Rule 8 of the 2013 rules is reproduced herein. 8 power to relax, where the governor is of the opinion that it is necessary to or expedient to do, he may, by order and for reasons to be recorded in writing, and in consultation with the Mizoram Public Service Commission, so the Department of Personnel and Reform, relax any of the provisions of this rule with respect to any class or category person. Now, 10. Rule 8 of the rules, 13 rules has reserved the power to governor by providing that if he is of the opinion that it is necessary or expedient so to do, he may, after consultation with the Mizoram Public Service Commission, through Department of Personnel and Administrative Reform, by an order with reasons recorded therein, relax the provisions of the 13th rules with respect to any class or category of persons. This court, in exercise of power of judicial review under Article 226 of the Constitution, is not supposed to exercise the power to override the provisions of the rules framed in the exercise of the power under the proviso to Article 309 of the Constitution, as they are legislative in nature and character on the consideration that a person, though not having the education qualification under the such rule, shall be promoted to a higher post merely on the basis of his experience. Such a direction could tantamount to altering the provisions made by the governor under Article 309 of the Constitution of India. It is seen that the power to relax any of the provisions of the 2013 rules with respect to any class or category of person rests exclusively in the governor as provided by Rule 8, and such power cannot be taken over by the court. The division bench in its order dated 13/10/2015 took note of its important matter, settled position of law that the power of relaxation can be invoked to meet a particular hardship even in an individual case by referring to the decision in Amrit Singh versus Union of India and others reported in 1980, CSCC 390. That I will rely on for your lordship. And Venkateswara Lu and others versus government of Andhra Pradesh, reported in 1996, SCC 167. As the basic grievance of the petition hearing was that he had been made to stagnate in his service career because of the insistence of the degree qualification. The division bench was of the opinion that in view of the rule of relaxation contained in the concerned recruitment rules, that the state respondent should dispassionately consider the case of the petitioner herein with the invocation of such relaxation clause, and also by taking into account the stagnation being faced by the petitioner hearing. In 12, my lord. In the state of Gujarat and others, Arvind Kumar T. Tiwari and other reported in 2012, 9 SC 545. The Honorable Supreme Court has observed that the two terms eligibility and qualifications are not synonymous. Eligibility connotes the minimum criteria for selection that may be laid down by the executive authority, public legislature by way of any state or rule, while the term qualifications may connote any norms laid down by the appointing authority before a candidate
Fulfills.
before a candidate is considered for a post, he must fulfill eligibility criteria. The appointing authority is competent to fix a higher score for selection than the one required to be attained for mere eligibility, but by way of its natural corollary, it cannot be taken to mean that eligibility of the norms fixed by the statute or rules can be relaxed for the purpose to the extent that M may be lower than the one fixed by the It has also been observed that in a particular case where it is so required, relaxation of even educational qualification may be permitted, provided that the rules empower the authority to relax the eligibility in general or with regard to an individual case or class of cases of undue hardship. A note of caution has also been made to the effect that power of relaxation should be exercised for justifiable reasons, and it must not be exercised arbitrarily, only to favor an individual. The power to relax the recruitment rules or any other rule made by the state government or authority is conferred upon by the government authority to meet any emergency situation where injustice might have been caused or is likely to be caused to any person or any class of persons, or where the working of the state rules might have become impossible. Now, last the direction of the Honorable Court, my lord. Upon consideration of the aforesaid facts and circumstances, more particularly the fact that the petitioner has been serving in the post of time consultant for a period of more than 9 years, we are of the considered opinion that as the Rule 2013 rules itself has provided for the power of relaxation of any of the provisions of the 2013 rules, with respect to any class or category of person, the respondent should consider the case of the petitioner in terms of the provisions of the Rule 8 quoted above by taking into account all the relevant factors into consideration for the purpose of further consideration of his case for promotion to the post of deputy director and promotion wing SCRT, and it is accordingly directed. The required exercise in terms of the said order shall be carried out and completed as expedient as possible, preferably within a period of 6 months from the date of annexing the particular order. It is, however, made clear that this court has not observed anything as regards the merits of the claim of the petitioner as regards relaxation, except to the extent indicated above. Now, since another judgment that already been relied on, this 97 and 98.
That
That-
already
that has-
relied on by this
Yes.
division bench.
Yes.
J.C. Jadhav, isn't it?
No.
No.
This is 98 is Ashok Kumar Upal
Ashok Kumar Utpal.
and another 2017 1997 10 SEC Sandeep Kumar Sharma that
Ah.
has been already recorded by your lordship in the order.
Earlier.
Yeah. That part is there, my lord.
Hmm.
And probably I should not repeat the same.
No, that we have read.
Now, J.C. Yadav. This is the larger way. These are 1990.
Paragraph 10.
Yes.
Isn't it?
Yes. On a careful scrutiny of the rules in its various aspects, we do not agree with the observation made in this thing case. Though Rule 22 is not happily worded, as apparently it gives an impression that no general relaxation can be granted by the state government. But on a close scrutiny of the scope of the power, we find that a narrow construction of the rules would nullify the government's power of relaxing rules to meet a particular situation. Rule 22 is beneficial in nature. It must constitute in a liberal manner, and it should not be interpreted in a manner to defeat the very object and purpose of the power. Power to grant relaxation may be exercised in case of an individual to remove hardship being caused to him or to a number of individuals who all may be similarly placed. This power may also be exercised to meet a particular situation where, on account of the operation of the rules, hardship is being caused to a set of individual officers. In the instant case, the appellants were found suitable for promotion by the screening committee, the commission, and the state government and the contesting respondent. Yes, they was not found suitable even otherwise for promotion. The state government granted relaxation of rules 6B in favor of the appellant. In such a situation, it is beyond comprehension that the power of relaxation under Rule 22 was exercised arbitrarily or that it caused hardship or injustice to anyone. On the formation of the new state of Haryana, no promotion from class 2 officers could be made to class 1 service without granting any relaxation since 1966 to 78. In 71, 72, 11 vacancies in the post of executive engineers were filled by promotion from class 2 officers. Although none of them had completed requisite period of service prescribed by the rules for promotion in 1976, 77, 77, 78, at 16 and 9 vacancies, respectively in the post of executive engineers were filled by promotion by granting relaxation as no officer of class 2 service possessing requisite number of years of service was available for promotion in 20%. Lastly, it is having regard to this fact and circumstances, we find no illegality in the appellant's promotion pursuant to the relaxation granted by the state. That the power to relaxation has to be exercised carefully and without any arbitrariness or discrimination to any. That's the partition. Now, Lordship will find this 2010 9 SEC 4969.
Which judgment?
2010, my lord. This is
Party's name?
Tanti Associates Private Limited.
Which, Steel Authority.
Yes.
Then
2010 9.
Ashok Kumar Yadav. Steel Authority.
Very good. There are
Mohinder Singh Gill. Ravindra Bhatt. A.K. Nayar. Mohinder Pal Singh Gill. It is for the affidavit purpose. Not for the- No, that is not. What is the party's name you say?
this is Tanti Associates Private Limited.
We have Susmita Sutradhar. Then Jonu Thara. Then J.C. Jadhav. Then Ashok Kumar Uppal.
How to apply this?
Steel Authority of India. What is the proposition in that
My
case?
lord, here, my lord, when any impugn order has to be passed, the reason has to be
That is a general principle, Article
Yeah.
40.
that
Every state action must be supported by reason.
the reason. And this 5 judges constitutional bench also referred to it. So this 5 judges 1990 486 that is there. If otherwise not necessary, I will
Give a copy.
I'm just reading out and I'll
Slowly read.
46, my lord. Para 46.
Okay, para 40. I read them.
The position in the United States has been indicated by this court in the S.N. Mukherjee in SEC Union of India. This court held that in the United States that courts have always insisted on the recording of reasons by administrative authorities in exercise of their power. It was further held that
That's why we call for the record. For
And-
this principle of law.
Yeah.
Law is also equally settled that the reason may not be explicit in the order itself, but in exercise of power, we can go to the record and have a satisfaction whether it was based on reason or not. That is a well settled principle.
and already to that extent, my lord, already whatever the record, photocopy record was submitted by them, I've gone through it, but no such reasons have been in that record. Should I read, my lord? It was further held that such recording of reasons is required as the courts cannot exercise their duty of review unless they are advised of the consideration underlying the action in the review. In S.N.
What is
Mukherjee,
the date of rule coming into effect? 13?
13/6/2000. In S.N. Mukherjee case, this court relied on the decision of the U.S. court in Securities and Exchange Commission Principle, and it is often discussed above. Summarizing the above discussion, this court holds: 1. In India, judicial trend has always been to record reasons, even in administrative decisions, if such decisions affect anyone prejudicial. A quasi-judicial authority must record reasons in support of its conclusion. C. Insistence on recording of reasons is meant to serve the wider principle of justice that justice must not only be done, it must also appear to be done as well. D. Recording of regions also operates as a valid restraint on any possible arbitrary exercise of judicial and quasi-judicial or even administrative power. Regions reassure that discretion has been exercised by the decision maker on relevant ground and by disregarding extraneous considerations. Well, this is there. I'm just there.
Keep the What is the qualifying service?
To be
One is first earlier rule, qualifying service,
only 5 years, my lord, to be pro
5 years, and group B.
and group between. The 5 years and group B training already I have. And regarding reasoning, my lord, the recording of reasoning, I have also applying this 99 for a 5 years. That
DPC was 4/6, 2019,
90
and
and last
21/12.
24.
Hmm?
24 12. Now, 2008 9 SCC 407.
Hmm.
This is still authority probability evidence. Still authority India limited versus Caltex of the
What is the ratio?
relevant para 17.
What is the ratio?
This
Same, similar ratio.
region is the heartbeat of the applicant.
That's not necessary. These are not judgments nowadays. Required.
And
Anything on relaxation, that's all. Reason is
Yes.
that's all.
this is regarding relaxation. These are I have relied on my lord.
Okay. One to judgment is enough. Yes. Mr. Nayak. So far relating to the challenge, you need not address. Lot. His whole case is that their cases are considered they were on same footing, my case is not considered. Your one of the answer would be from the record I have gathered is that the question of consideration of them will not come as on 4/6/2019, none of this person has acquired the Group B training, even to consider under the earlier rule.
Okay, 1/3 has been given.
Ah.
What it will state here, the date
That's why. That's
on
why.
which they acquired the Group B training. Now, Lordship, I am coming to the earlier judgment.
Where is that?
Earlier judgment. Is at page 86 of the resolution.
They approach this court.
Yes, sir. 3-4 petitions were there. Ultimately, court.
Just tell us for our record, who preferred, who are the present writ petitioners, they were part of the earlier proceeding?
Yes.
Just
All
tell.
all these petitions.
Similar.
Yes.
Okay.
Yes.
Three writ petitions are there. They were there.
It is judgment dated 7/10/2021, Lordship. I'm coming to
Paragraph 7.
it's not from page 83. I'm coming to paragraph 6,
Paragraph 6.
page 91.
Okay.
Page 91, Lordship, paragraph 6. The preliminary objection is taken up first. It is seen that the petitioners have not challenged the eligibility criteria prescribed in the Assam Secretariat Service Bill 2019. Their collective grievance is only limited to the non-disposal of their representation seeking relaxation of rules by projecting that several similar situated persons who had the educational qualification of higher secondary pass were promoted to the rank of superintendent in the Assam Secretariat after the State Secretariat Service Bill 2019 came into force. So this maintainability question was denied, Lordship. The last page 92, Lordship, paragraph 7. The Learned Standing Council for the phone number 2,
Just a
3,
minute.
page
Be that
9.
as it may have been taking note of this paragraph 7. Case of the projected petitioners, the Assam Secretariat contains provisions of relaxation rules without examining the merit of the claim. The considered the ends of justice will be met if the representative disposed of at the motion stage by directing Chief Secretary
Yes.
Authority rule under Assam Secretariat Service Rule to dispose of the representative petitioner on 9/6/2020 Annexure F as well as represented submitted by.
Okay, in that case also, Lordship,
That-
110.
That order was passed. Lot will know that para 8. That without going to the merit of the case. That is correct. Having taken note of the case as protected by the Assam content period for relax
You are
Without
relying
examining
on
the-
this order,
Yes.
paragraph 7,
Yes, paragraph 7.
7 and 8.
period of 2 weeks from date of receipt of the downloaded copy.
Yes, that
Ah.
was the stand taken in that case also, Lordship. Ultimately, court directed the department to dispose of their
And what is the
representation.
other case?
Similar, Lordship. Rule was not challenged in any of the cases, Lordship. However, the rule is presently under challenge, Lordship, with pending before the division and some other cases. Accordingly, Lordship, page 100, Lordship, the speaking order was passed.
Please, 100.
Page 100, Lordship, the 2-page order. Your Lordship has already perused that order. I'm not. Lordship, may kindly see page 101. Last paragraph, Lordship. Whereas no candidate without required education qualification, that is graduation, has been considered for promotion to the post of superintendent after amendment of the said rule, whereas the Secretariat Administration Department has repealed the earlier service rule by the Assam Secretariat Service Rule 2019, where the recruitment to the post of superintendent shall be made by promotion from the select list prepared for this purpose under Rule 7 from among the senior administrative assistants in the secretariat who have rendered not less than
Just to
5.
understand, your distinguishing factor is that, see, these are people, you are a class of people who have not acquired the qualification even on the repeal of the earlier rule.
On the date
On
of
the date, number
repealment
one.
of the
Number
earlier rule,
two, you were not acquired the qualification when earlier process was initiated. So therefore, it cannot be said that you are equally footed with those persons whose cases are considered. Not only they are senior to you, but they had already acquired their their qualification, and above all, their cases were recommended in terms of the earlier rule much prior to the
coming into effect
publication of the
new
rule, and therefore those cases went on consideration even after the rule, though the report may be, though the promotion might have been issued by subsequently, but determination was made, recommendation was made prior to the date of
at least initiated. Prior
initiated,
to the coming into effect of the
initiated, recommended, initiated for coming. What
On-
about the 24th?
on the, I'm coming to the,
Yeah.
on the basis of this submission, Lordship, I have 4 points to make as so far as the speaking order is concerned. One, Lordship, it is elaborately
Dealt.
with Lordship. Second, Lordship, it's a regional order. Lordship has already perused the document. And Lordship was prima facie satisfied on that day. Lordship, regions are definitely there. Three, Lordship, as regions are there, it cannot be termed as arbitrary. That is my submission, Lord. And fourth, speaking order do not cause any prejudice to the petitioners as no accrued right of the petitioners has been violated. On the day when the speaking order was passed, or on the day when the new act came into effect, they were not eligible to be considered for promotion to the next level. So no prejudice was caused to them. So far as the speaking order is concerned, these are my specific topics. 1, 2, 3, 4. Now, Lordship, may come to the rule law. Yeah.
This is the rule.
Yes, Lordship, may kindly see
This
Assam.
is the rule, Mr. Nair.
Yeah, no, earlier one law.
This is the 2019, 1st of June.
I'm taking the 1963.
No, so where is the 63 rule? There's some service manual.
Assam, no, not
Any annex?
not extra. Lordship, may first take the Assam Secretariat Service Rule 1963.
Okay.
Secretariat Service Rule 1963. Lordship, may kindly see section
25.
Rule 8. Rule
Rule 8.
8. I'm taking the other one. Rule 8.
Just a minute. 3, 4, 5, 6, 7. Rule 9. I've got the rule 9.
Rule 8 is here. But I have
Typist. Rule 8. Superintendent.
no, Lordship. Yes, superintendent.
Ah.
Yes. Recruitment to the post of superintendent shall be made by promotion from the select list prepared for this purpose under Rule 10 from among upper division assistants in the secretariat who have rendered at least 5 years of service as upper division assistant and conform in this cadre.
Hmm.
Now, Lordship, confirmation will get in the other rule, Lord.
That is
That is presently they are regulated by Lordship. That is Assam Secretariat Subordinate Service. Now, Lordship, this is one rule to which they are seeking promotion, and now they are covered by the rule.
no. This is a rule where promotion of superintendent is given is
post-
Assam Secretariat Service Rule 1963.
Post of superintendent is covered by this Assam Secretariat Service Rule 1963.
That we have got. What is the qualification?
And presently they are covered by as senior assistant under Assam Secretariat Subordinate Service Rule 1963. It is Rule 25, Lordship.
Where do we get that?
Rule 25 has been marked. Rule for confirmation.
This is relaxation. This is 2019.
I have just not furnished.
Okay, confirmation. Okay. This
Confirm.
rule is called, mm,
This is Assam Secretariat Subordinate Services.
this is subordinate and this is
This is Secretariat Service.
secretary. Okay.
Lordship,
That is
this
pay
rule-
rule 25,
this rule,
confirmation.
Secretariat Service will start from Superintendent to Under Secretary,
Okay.
I mean Additional Secretary.
Okay,
And so far as subordinate rules is concerned, this is up to Senior Assistant Lord.
okay.
Confirmation Lordship.
Okay.
Subject to availability of a permanent vacancy, every member of the service shall be confirmed in the grade to which he is appointed if A, he has completed at least 1 year of service to the satisfaction of the appointing authority. B, he has successfully undergone the prescribed training and also passed the prescribed departmental examination. This is Group B, Lordship. And C, that is important, he is otherwise considered fit for confirmation by the appointing authority. So for
So
confirmation,
therefore it's a
three
DPC.
conditions are
This
there.
is the
Even if a person has not passed the Group B training, his service may be confirmed. And if he is confirmed, that he can be considered for promotion to the post of superintendent. So having a Group B degree, I mean qualification is not always necessary for confirmation. That is my submission from the rule, Lord. In the affidavit, my stand is at paragraph number 4, Lord.
Yes.
Paragraph number, just now your lordship has read that paragraph. I am not going to if all the affidavit. The interim deponent is paragraph 4. Lordship, here we have basically we have taken the stand that the first DPC took place here. It is the date has been mentioned as 4/6/2019, but from record it appears, Lordship, the initial date was 26/2/2019 now, when the first DPC took place. Lord.
I've seen that.
Here in the record it is apparent, Lord. 26/2/2019.
Just flag mark it.
Yes, Lord, I have flagged. So far as the post of deputy secretary is concerned, Lordship, their services were some of relaxation was applied in their case because there were no eligible candidates. Posts were lying vacant, but there were no eligible candidates there. That is why decision was taken with the approval of the
But these
president.
people were not eligible.
Otherwise,
They were not became,
so far as that
yes.
age factor is concerned, I mean the qualifying.
Even
years
if he's
are concerned.
qualified, they did not come into the zone of consideration by virtue of their
So far as
seniority,
so far as yes, seniority means seniority in terms of qualifying years.
service.
So that was condoned, that was relaxed by from approval of the personnel department, as there were no eligible persons Lordship to be promoted to the post of deputy secretary and vacancies were there. But in this case, no such situation is there. Here, number of eligible candidates are there and who are eligible in terms of the new rule. So they cannot be bypassed by relaxing the rule in for the petitioner's Lordship, and it will cause prejudice to the persons who are already eligible under the new rule, Lord. And not relaxation, not grant of relaxation is one of the that is one of the reasons for not granting relaxation to the.
Equitable consideration.
Next, I am coming to 2-3 judgments. One case has been given.
We have seen.
Lordship, first I am reading Lordship Vikas Singh.
Which paragraph?
Vikas Singh, Lordship, I have marked 4.1, 6, 4.1, 6, 7, 7.1, and 8, Lordship. Lordship. This is page 350, Lordship, 350. Judgment is there, right? 4.1. It is submitted that grant of relaxation under the 2006 relaxation rules is discretionary and no writ of mandamus can be issued directing the competent authority to grant the relaxation. It is submitted that word used in Rule 4 of the 2006 relaxation rule is may. Same is in our case also. And only in case where the required number of eligible persons are not available in the field of eligibility, it is submitted that no employee can claim the relaxation as a matter of right. Paragraph 6, Lordship.
Mm.
We have heard the learned senior advocates appearing for the respective parties at length. 7. At the outset, it is required to be noted that the learned single judge should the writ of mandamus commanding the competent authority to grant the relaxation as per Rule 4 of the 2006 relaxation rule in qualifying service and consequently has quashed and set aside the eligibility list dated 18/3/2019 and 15/5/2019. At the outset, it is required to be noted that as per Rule 353 of the 1990 rules, one of the conditions to be eligible is that the superintending engineer must have completed 25 years of service, including at least 3 years of service as superintending engineer. It is an admitted position that the original petitioners did not fulfill the eligibility criteria as they did not have the qualifying service of having completed 25 years of service. Thus, the eligibility list were prepared by the department absolutely as per Rule 5.3 and 8.3 of the 1990 rules. The names of the original petitioners were excluded from the eligibility list of superintending engineers for promotion to the post of chief engineer on the ground that they did not fulfill the eligibility criteria as per Rule 5.3 of the 1990 rules. Therefore, as such, the High Court ought not to have set aside the said eligibility list, which as such were prepared absolutely in accordance with the 1990 rules. 7.1. The learned single judge thereafter, while quashing and setting aside the eligibility list dated 18/2019 and 10/5/2019, has issued the writ of mandamus commanding or directing the competent authority to grant relaxation in qualifying service, which as such was permissible under Rule 4 of the 2006 relaxation rules. The word used in Rule 4 of the 2006 relaxation rules is may. Therefore, the relaxation may be at the discretion of the competent authority. The relaxation cannot be prayed as a matter of right. If a conscious decision is taken not to grant the relaxation merely because the rule permits relaxation, no writ of mandamus can be issued, directing the competent authority to grant relaxation in qualifying service. Therefore, the High Court has committed a grave error in issuing the writ of mandamus commanding the competent authority to grant relaxation in the qualifying service. Consequently, the High Court has also erred in quashing and setting aside the eligibility list dated 18/2019 and 10/5/2019, which as such were prepared absolutely in consonance with the 1990 and 2006 rules. The impugned judgments of the order passed by the learned single judge as well as division bench of the High Court are not sustainable in law. In view of the above, and for the reasons stated above, the present appeal succeeds. The impugned judgment and the order passed by the division bench passed in State of UP versus Vikas Kumar Singh and judgment on order passed in single judge dated 11/12/2019 passed in Vikas Kumar Singh versus State of UP are hereby quashed and set aside. Consequently, the writ petition filed by the original petitioner being writ petition number 7 then dismissed. So this is the law settled by the Supreme Court law.
And similarly, we'll place reliance on this. That
Second-
relaxation of rules so far relating to educational qualification cannot be done by Syed Khalid Rizvi and others.
That is the main judgment, and
That is the main.
and the basis is that Keshav Kumar Jyoti law.
And others are
In the present case, Lordship, one judgment passed by the Iowa High Court, Lordship, in respect of the same department.
same
Lordship,
department
one
regarding
Raghuramani Singh law.
that Justice Surana's judgment.
Yes, Lordship, there I am.
That
relying
they say that we cannot relax the rule, we
In
cannot
fact,
issue
the
it.
relaxation that has been
Set
granted
aside.
was set
Set
aside by the court, Lordship. This is paragraph number 3, 15 and 23.
Only in this case, my lord.
Just a minute, just a minute. Paragraph 315 and
23. 15 to 23.
that is, I'm having that.
So, Syed Khalid judgment, I am not reading, Lordship. Keshav Jyoti, I am not reading.
Raghumani Singh, I have read it.
Raghuramani Singh,
I have read it.
It is already there.
It is read it.
Another judgment, Lordship, I am reading is 2011 2 CLT 686.
That is answer is judgment. DB.
paragraph 24 and 30. Two paragraph only, Lordship. It is time to recall that paragraph 24. It is time to recall that the concept of direct appointment, absorption, promotion in service in relaxation of the relevant recruitment rules has undergone prominent development. The present view is that there can be no relaxation of the basic and fundamental rules of the recruitment. Thus, the service jurisprudence now makes a distinction between conditions of recruitment and conditions of service. While a condition of service may be relaxed, condition of recruitment cannot be relaxed. Subject, however, to the condition that if the recruitment rules in themselves provide for relaxation of the condition of recruitment, the condition of recruitment may be relaxed, provided that such relaxation does not render the conditions of recruitment as a whole negatory and or non-is in its entirety. Lot of educational qualification is a substantive qualification. Then lot of I am coming to paragraph 30. Yes, Lordship. This is the conclusion. The decisions referred to by the division bench in DM Life Plan make it clear that even if the recruitment rules in a given case contains provision for relaxation of the rules of recruitment, such relaxation cannot be to such an extent that it makes the whole scheme of recruitment meaningless, nor can the provisions of relaxation be interpreted in such a manner that it enables the government to throw away the rules of recruitment, lock, stock, and barrel, make the same non-existent as if the rules as a whole do not exist, or as if the rules in their entirety and substance. In fact, in Vivekananda Das versus State of Assam and others reported in so and so, one of us answering is dealing with the developing concept of relaxation recruitment was observed. From what has been discussed above, it is abundantly clear that though Rule 23 provides for relaxation of any rules, and even if any rule is interpreted to include the rules of recruitment, relaxation cannot be to such an extent that the rules of recruitment are rendered fragile. So these are the basic judgment. Lot of one judgment, lot on that day of time.
That I have the citation I have recorded.
That citation is 1991 3 SCC 38. Paragraph 2, 4, 8, 9, and 10. What if here Lordship will get when in the
1990.
1991 3 SCC 38, paragraph 2, 4, 8, 9, and 10. Lordship will get here the law relating to when in an administrative decision, results are not required to be recorded.
For reasons we are not going prima facie because office record we have seen. You have your reason, but this case is something different.
Lord, I like to keep the record.
I have flag mark it.
Here, but small flag marks are there. But if one specific candidate was here, it is Jagneshwar Rajpal Lordship. He was promoted subsequently, but in case DPC already recommended him, Jagneshwar Rajpal was selected for promotion to the post of superintendent.
One of the petition.
In the last DPC meeting held on 19/11/2018, however, the promotion could not be made due to pending departmental proceeding against him. So he was subsequently promoted. Then Lordship, one list is there, Lordship.
Just flag mark the list.
Yes. This I have green flag Lordship. Here Lordship will get 54 number of candidates Lordship. And the last person, the junior most candidate in this list was 31/12/2011. He was promoted to the post of senior step on 31/12/2011. And in the present case, Lordship, the senior most person was promoted in the year 2012. In the form that this got one, this I have got. In
You
this
have prepared a list. I've seen.
yes, in this Lordship will see 5 years minimum qualifying period is required. Lord. Here only 3-4 persons, that is serial number 1, 5 years completed, serial number 2 completed, serial number 3 completed, serial number 4 not completed. He was promoted to senior in the year 2014. Then Lordship will have serial number 9 and 10. They have completed 5. So out of the 17, only 5 were eligible to be considered in the year 2019, so far as that qualifying period is concerned. Neither of them have completed the grade B training. That is, neither of them
Because serial number 19 completed grade B on in the year 2020.
No, grade B, neither of them completed grade B lottery prior to the coming.
No,
into
that's
effect.
right.
And so far as qualifying service is concerned, 5-year service lottery,
These 4 partners have already counted.
Lot.
Uh,
only 5 of
serial
them,
number 1, serial number 2, serial number
3.
uh,
3
3,
completed
serial
5 years.
number 9, and serial number 10.
Only,
Is that it?
only. Others were not eligible. So no, there is no question of anything. So these are my basic submission lottery.
Carrying concluded session.
That whatever Roghumani thing had already been accepted. And that case, my lord, the state proper state by promotion. That was as per the certificate. Merit come senior, not seniority come. We are seniority company. Secondly, my lord, this judgment, my lord, though Justice Jadhav case with the 3 judges, that has resigned. And this case can be considered by the government by way of cabinet approval. And now only it's the matter that to the court
Division bench.
and according to my lord,
Forget about
every
it.
party also already approached the citizen for my information. So only the Justice Jadhav case, 3 judges, that has not been referred. Otherwise, only my prayer will be that since the petitioner at the box of retirement, that undue hardship was not there. The Roghumani Singha case. That has to. If there is no hardship, that cannot be considered. Then my hardship is there.
Your basic case is by the division bench in Kohima, where other judgments have been relied on and explanation is given under what circumstances, what is undue hardship, and isn't it? Okay. Could not dictate that it.
Yes.